Okay, good afternoon, everyone. Let's go on the record in State of New Mexico versus Miranda Chavez, T4DW 2020-1613.
Graham Conlon for the state, Your Honor.
Good afternoon, Your Honor. Osama M. Rashid from Rashid & Associates, appearing on behalf of Ms. Chavez, who's present in my office, and we are appearing by Zoom.
Okay, welcome. Good afternoon, everyone. And parties, just as a threshold matter, Mr. Conlon, is the state ready to proceed to trial today?
We are, Your Honor. Officer Lujan is present via Zoom today. The state would request that for some preliminary matters that Officer Lujan be placed in a breakout room so Mr. Rashid and I and you can discuss those matters.
Of course. Okay. And before I get there, Mr. Rashid, is defense ready to proceed today?
The defense is ready to proceed, Your Honor. There was one issue that the state had provided us apparently last night with a Giglio questionnaire regarding Officer Lujan that provided that all of the responses, or the primary ones, were refused to be answered. I brought that to Mr. Conlon's attention, and then 5 minutes before we started here today, he provided a newer or another Giglio questionnaire that had those responses. I emailed him quickly and asked if those were Officer Lujan's responses from today or what the situation was, but then I had to get on, so I don't know what the answer is to that.
And Judge, I sent those. First off, I do appreciate Mr. Rashid's professionalism in bringing that to my attention. He is correct. I submitted outdated responses. The DA tried to create an efficient system in terms of obtaining responses and then making it so that the ADA and the officer could just speak about the current case issues. NMSP changed its policy regarding Giglio prior to today. The responses I submitted, part of them were outdated. At 11:51 a.m., the state did provide Mr. Rashid updated responses obtained from Officer Lujan. He and I spoke at 11:47. I read him the questions individually, remedied the matter. I also brought this attention to Chief Deputy District Attorney James Grayson to let him know not only that I made the mistake, but also that there are some issues with our IT system for the Giglio database. First off, one response has Officer Lujan's name spelled wrong. And then secondly, the two current ones, one of which are outdated prior to NMSP changing its policy.
Okay. And so, Mr. Rashid, is there any remedy that you're asking for regarding the Giglio disclosure?
Honestly, Judge, I don't love that that's something that they would provide at 6:58 p.m. the day before trial anyway. It would seem like if there are issues with reference to, and I pronounce it Giglio just because I knew somebody with that last name and that's how they pronounced it.
Okay.
Okay. I don't care. I can call it Giglio if that helps anybody. But under the circumstances, I think that it's not a great idea for that to be received the night before trial, and then for the answers to be all refused, and that be something that we are then trying to be updated on minutes before trial is to begin. So I think under the circumstances, I kind of feel like it's appropriate for me to request a continuance based on the late disclosure of that information. But it's not the biggest issue with Officer Lujan. So, you know, it's what I would call a soft motion for a continuance based on the late disclosure. But if the court prefers to just proceed, then I guess I can do that too.
My strong preference is to proceed. We have a rule date of July the 6th, and I don't have many trial slots open between now and then. I know that both you and Officer Lujan have been around a lot longer than I've been on the bench. If it's something that you feel you need time to review, I guess we can consider it and try and find some time, but I'm more inclined to move ahead. What do you think about that?
I think, well, can I just run it by my client very quickly and go off camera and all that?
Sure.
Thank you.
Yeah.
I'm back, Your Honor. Thank you.
Sure.
I've spoken with Ms. Chavez about it, and if it wasn't Officer Lujan, I probably would push for the continuance based on it being Officer Lujan and me not thinking that even clarifying those responses is going to be overly helpful in Ms. Chavez's defense. So I guess we'll just proceed.
Okay, and so with that, Officer Lujan, I'm going to put you in the waiting room. We've got a number of pretrial motions to go through. So I'm just going to move you to the waiting room, all right?
Okay, yes, Your Honor.
Oh, and actually, Antonia, in the courtroom, if you could either designate me a host or just move Officer Lujan over, I'd appreciate it.
I'll go ahead and move him, Judge, if you like, but if you want me, I can put you host as well.
Let's do both. Why don't you go ahead and move him first, make me a host while I talk to the attorneys, okay?
Sounds good.
Great. There we go. All right. And so there are a number of pretrial motions. I did receive the state's intended exhibit list, the defendant's motion to exclude opinion testimony by the arresting officer, defendant's motion in limine regarding the horizontal gaze nystagmus, and then our substantive motion is the motion to dismiss / motion to suppress for lack of probable cause. So I'd like to start with the motion in limine regarding the horizontal gaze nystagmus. I've reviewed the motions in the case law cited by the attorneys. Mr. Rashid, you're the moving party. Is there any additional testimony you'd like to present or any argument you'd like to present regarding this motion?
Well, Your Honor, a lot of it, and I filed the horizontal gaze nystagmus test motion and the field sobriety test motion, kind of anticipating that we'll have to address them once the state attempts to lay foundation and then argue those. So I don't necessarily usually address those pretrial because they are so dependent on what the state does as opposed to what the status of the law is necessarily. I think we all agree that Lasworth is Lasworth, Torres is Torres, that we have the cases that we have. And then the field sobriety testing one just depends on the information that they lay and the foundation that they lay in trial. So I don't know that we really need to address those in advance. And then with reference to the probable cause and motion to suppress, obviously the state will have to present that evidence and testimony and go from there.
Okay, so defense would like to address those when we're in the hearing. Okay, and so then with that, I also received the state's proffered exhibit list, so I'll reserve ruling on each of those 3 exhibits based on the testimony presented. In parties, I usually do the motion to suppress with the rules of evidence in application and then just combine that over, roll that over into the trial in the event that I deny the motion to dismiss. Does that work for both of y'all?
Mr. Conlon, I think you're muted or something.
I'll speak up. My apologies. Yes, Your Honor. The state did not intend to elicit any testimony regarding eye movement for the horizontal gaze nystagmus test. So I planned ahead of time just because I recognize the rules of evidence to apply to this PC hearing.
Okay. Okay, Mr. Rashid?
Your Honor, I'm generally speaking reluctant to agree to roll it over into the trial or we've actually done. So while I may very well agree to that at the conclusion of the evidence, I don't know that I could agree to it in advance as the state has.
Okay.
Like I have not had the occasion to require or be enough of a jerk to require that the state just do the case again. If the evidence and testimony is as I expect it to be, I don't think that that'll be a problem, but I also, if the evidence and testimony is as I expect it to be, don't think we're even going to get there.
Okay, I'll note the defense does not stipulate to the court's proposal. We'll proceed and then take that up depending on the ruling of the motion. Okay, so now we've got the motion to dismiss and suppress for lack of probable cause. The burden shifts to the state to present evidence. Let me ask, does either side have any opening statement regarding the motion? I'll start with the moving party defense.
Your Honor, I will make a brief statement here. I think under the circumstances of Ms. Chavez's arrest, the court is going to see that while she was driving at a high rate of speed, there was nothing else about her driving that was illegal or of concern. She responded appropriately to the officer's emergency equipment. She responded appropriately when he approached the vehicle and asked for documents. She responded appropriately when he asked her to step out of the vehicle. She moved to the place where he asked her to move. He then administered field sobriety tests, which I think she did extremely well on, to the point where if a person that does this well on field sobriety tests still gets arrested, I don't know that there really is much room for people to be able to satisfactorily perform these tests. We're talking about somebody who doesn't make significant mistakes whatsoever on the walk and turn test. She keeps her foot up the entire time on the one leg stand test. I think the court will have issue with a couple of the clues that the officer has claimed he's seen. And we intend to argue that there is not sufficient evidence for the officer to have made an arrest in this case, and we'll be asking the court to suppress.
Okay. And Mr. Conlon, any opening from the state?
Your Honor, the state just asked that you look at what evidence is presented to you, not merely what evidence is absent in this matter, and the state will then make its arguments and cite case law at the conclusion of the presentation of evidence.
Okay, thank you. With that, the burden shifts to the state. So Mr. Conlon, please call your first witness.
The state calls Officer Lujan to the stand, Your Honor.
Okay, and Antonia in the courtroom, is he in the waiting room?
He is.
Oh, he's in a
Judge.
breakout. He's in a breakout
He's in
room.
a
Okay,
breakout room. Yeah.
okay, I'll move him in now.
And Judge, just so that you and the state are aware, the way my computer is oriented in my office, and for me to have both my client and I on video, I do have to essentially work here and kind of go back and forth. So I'm not trying to avoid the camera or not. I'm not trying to be disrespectful to the court. It's just the layout of the office and the way I have to do it.
Okay. Okay. There we go. And Officer Lujan, could you turn on your camera and microphone?
Yes, Your Honor. I'm sorry about that.
There we go. Let me go ahead and swear you in. Could you please raise your right hand? Do you swear and affirm that the testimony you give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Okay, thank you. With that, Mr. Conlon, your witness.
Thank you, Your Honor. Officer Lujan, can you please state your full name for the record?
Yes, sir. Raimundo Lujan III. I'm a full-time sworn salary commission police officer with the New Mexico State Police.
And how long have you been employed with New Mexico State Police?
I've been employed with New Mexico State Police since May of 2015, so just over 6 years.
And how are you currently assigned?
I'm currently assigned to the Uniform Bureau of District 5 Albuquerque. I'm also assigned to the DWI unit full-time.
Can you briefly explain the selection process or just the process in general of how you are placed onto the DWI unit?
Yes, sir. It's just showing interest in, DWI investigations. You have to be proficient enough to go and teach DWI. With that, the only difference between a DWI officer and a uniform officer here in Albuquerque is we're entitled to go and teach other officers and recruits the standardized field sobriety test.
Okay, thank you. Were you on duty on October 24th, 2020 at approximately 11 p.m.?
Yes, sir. I was on duty in the city of Albuquerque, County of Bernalillo, and state of New Mexico. I was driving a marked New Mexico State Police patrol unit in uniform.
I'm going to object under the circumstances to the officer being non-responsive to the question. I understand that he's just trying to get through the information and weigh certain things, but if he's not asked about jurisdiction, he shouldn't be testifying about it.
I'll sustain the objection. Officer, please just answer the question asked by this state, okay?
Yes, sir.
So Officer Lujan, we'll back up just a little bit. So as you were on duty on October 24th, 2020, around 11 p.m., can you tell the court what your job duty was that night?
My job duties are to enforce traffic violations, investigate crashes, answer calls for service, and just serve the community.
And on that evening, can you tell the court what you were driving and what you were wearing?
Yes, sir. On that evening, I was driving a marked New Mexico State Police patrol unit. I was wearing a full New Mexico State Police Class A uniform, displaying my badge of office.
Okay. And on October 24th, 2020, did you come into contact with anyone who is currently in this virtual courtroom?
Yes, sir. I did come in visual contact with Miss Miranda Chavez. She's sitting to the left of Mr. Rashid. She's wearing, I believe it's a red and colored cover-up shirt with purple hair.
Okay, thank you. And Your Honor, the state would ask the record reflect that Officer Lujan has identified the defendant, Miranda Chavez.
The record will so reflect.
And on that evening, Officer Lujan, do you recall where you came into contact with the defendant?
Yes, sir. It was on Interstate 25 southbound near milepost 227 when I came in visual contact with her vehicle.
And can you tell the court, for milepost 227, what main thoroughfare is perpendicular to southbound I-25?
It's going to be Interstate 40, north and or east and west, and so we're approaching the Big I.
Okay. What street leads to exit 227 on southbound 25?
It's going to be Comanche.
Okay. And is that location in the city of Albuquerque, County of Bernalillo, State of New Mexico?
Yes, sir, it is.
Do you recall what drew your attention to the defendant that evening?
Yes, sir. Well, I was traveling southbound on Interstate 25. I did come in contact with, or visual contact with the pair of headlights approaching the rear of my patrol unit within the number 1 lane from center.
Okay, and I imagine a lot of headlights, are behind you when you're on the interstate. What particularly about this vehicle stood out to you?
Yes, sir. Well, I was traveling around the speed limit. I would say maybe within like 2 or 3 miles over the speed limit. I came in visual contact with that vehicle that was traveling within the number 1 lane from center. I was in the number 2 lane from center. And that vehicle began closing distance to the rear of my patrol unit very quickly, and it appeared to be exceeding the posted speed limit.
Okay. And before we continue with the investigation portion, just a clarification, can you explain to the court what the number 1 lane from center is versus what the number 2 lane from center is, and so on and so forth?
Yes, sir. The number 1 lane from center will be what everybody considers the fast lane. It's the lane closest to the median. We go 1 and then 2, 3, 4, and move to the right.
Okay. So after you observed the vehicle approaching from behind you at a high rate of speed, what did you do next?
Due to my observations in the vehicle closing distance very quickly, I did engage my rear radar stalker device.
And I do have a couple of questions about the stalker device. What training and experience do you have with the stalker radar device?
I received my initial training from the New Mexico State Police Academy, how to properly utilize the stalker radar device. That's the only radar device that I've been trained to utilize since I've been employed with New Mexico State Police. The initial training is you're with the instructor for stalker radar device, who is a member of New Mexico State Police, and they make you learn how the machine operates and then what you're supposed to do to keep it functioning before you start the shift.
And is part of the requirement to graduate from the academy successfully completing any training with the stalker radar device?
It's not a requirement. You could get your law enforcement certification without that stalker radar device. Certification is just one of the training that New Mexico State Police teaches their officers or the recruits in the academy setting to get you certified to operate that device.
Okay. And I apologize if I missed it. Are you certified to operate the radar stalker device?
Yes, sir. I am certified. I got my certification in the academy.
All right, thank you. And how do you calibrate the device?
So the machine comes calibrated from the manufacturer that makes the stalker radar device. The stalker radar device is installed in our patrol units before it's issued out to us. What we're doing is we have to do a calibration or tuning fork test, which
Excuse me just one second, Officer Lujan. Excuse me just one second. Your Honor, in order to save time, this is the kind of testimony that I don't feel that I would require under the circumstances. I don't have any doubt that Officer Lujan is trained on how to use a stalker radar device, that he used it, and that the court is likely to rely on its results. So rather than go through with a long foundation, we'll just stipulate to the testimony regarding his training and experience with the stalker device and just get to the issue at hand.
Okay, and Mr. Conlon, does the state accept that stipulation?
Absolutely, not a problem.
Okay, then let's move ahead with that testimony.
Officer Lujan, what speed was the defendant traveling at that evening?
after looking at the radar display, it read 89 miles per hour.
What is the marked and posted speed limit southbound I-25 near exit 227?
It's posted at 65 miles per hour.
After observing this traffic violation, what did you do next?
The vehicle actually traveled past my patrol unit, still within the number one lane from center. At this time, it was now approaching the Big I and made a lane change. I positioned my patrol unit directly behind that vehicle in preparation to conduct a traffic stop.
And after positioning your vehicle behind the defendant to conduct a traffic stop, can you tell the court what you did next?
Yes, sir. I engaged my emergency equipment, conducted the traffic stop on the gray and color Dodge pickup truck bearing a New Mexico registration on Interstate 25 near milepost 224, which it came to a stop on the right shoulder.
Okay. Based off your training experience, did the defendant have any trouble whatsoever coming to a complete stop on the right side of the interstate?
I didn't know any issues with that. She didn't hit anything. She didn't take forever to pull over. She pulled over on the right side. So
after the vehicle came to a complete stop, can you tell the court what was the next step in your investigation?
Yes, sir. As the vehicle came to a stop, I exited my patrol unit. I did approach the vehicle on the passenger side, which I did meet with the female driver of the vehicle. She did have a male passenger with her as well.
How did you identify the defendant as the female driver that night?
Yes, sir. I introduced myself initially, informed her the reason for the traffic stop, and requested her driver's license and vehicle information. The female driver did present me with her New Mexico driver's license, which I was able to identify her as being Mrs. Miranda Chavez, date of birth 6/1/1996.
Did you notice, or did you make any observations regarding the defendant providing you the documentation you requested?
Not any observations of when she presented me the documentations. It was just when I was having a conversation with her.
Okay, so let's talk about that conversation. After you received that documentation, what was the next step in your investigation?
Well, after I received all the documentations, that's when I requested her to exit the vehicle.
And why did you request her to exit the vehicle?
The reason for that is while I was speaking with her on the passenger side, I did observe her to have bloodshot, watery eyes. And I did detect a strong odor of alcoholic beverage emitting from inside the vehicle. Like I said, she did have a male passenger with her. So I wanted her to separate her from the vehicle as well as a male passenger and see if that odor still existed.
And once she exited the vehicle and you began to speak with her, what additional observations did you make?
Yes, sir. I had a conversation with Ms. Chavez outside face-to-face in front of my patrol unit. We were approximately in arm's length of each other while we had this conversation. While speaking with her, I was still able to detect that strong odor of alcoholic beverage emitting from her breath or her person. And I was able to still observe her to have that bloodshot, watery eyes.
During 2020 in the fall, were you wearing a face shield or mask because of the pandemic?
I was, yes, sir.
Okay. Did the defendant explain why she was in a hurry? Why she was speeding?
I believe she stated that she just got off of work. She had a long way to go, and she was just trying to get home, especially because it's late in the evening.
Okay. Where do you recall where the defendant works at?
I know it was kind of like distillery type business. I can't tell you the exact name though.
Okay. Given that you detected the odor of alcohol and the associated bloodshot watery eyes, did you ask the defendant about consuming alcohol?
Yes, sir. I did ask her about the consumption of alcoholic beverages prior to driving.
And what was her answer to you?
Ms. Chavez did admit to consuming one shot. I believe she stated it was approximately at like 7 p.m.-ish. And then she did advise that she had one beer, which I believe her last drink she advised was at like 10.
After the defendant admitted to consuming alcohol prior to driving, what was the next step in your investigation?
Based on my observations, as well as the admission from Ms. Chavez, I did have her perform a series of standardized field sobriety test SFSTs.
Okay. And before we go into the actual SFSTs that were administered, I have a couple questions kind of based off your training experience. Can you tell the court what standardized field sobriety tests are?
Standardized field sobriety tests are a battery of tests. There's 3 total that law enforcement officers are trained to utilize to determine if somebody is safe to operate a motor vehicle. These tests are designed to divide the subject's attention. It requires them to use physical skills as well as mental skills, which simulates to driving a motor vehicle.
Can you go into a little bit more detail about how these physical skills and mental skills simulate driving a vehicle?
Yes, sir. You have to have physical control of your steering wheel, gas pedal, brake pedal. You also have to have mental tasks required with driving is, identifying speed limits, traffic signals, turning red to green, green to red, stop signs, speed, other traffic, their movements and everything else.
Okay. Can you describe for the court what training you've undergone in DWI detection investigations?
Yes, sir. I initially graduated the New Mexico State Police Academy. That's where I attended and received my initial training on the SFSTs, the standardized field sobriety tests. Since then, I've graduated. I've also proceeded further investigations for SFSTs. I've went to ARIDE, which is Advanced Roadside Impaired Driving Enforcement class. I've also attended the SFST instructor course, where I am one of the instructors for the New Mexico State Police. I just recently got my master instructor cert for the standardized field sobriety test. I've also attended the Medical Foundations of Visual Systems taught by Dr. Siddick in Tampa Bay, Florida.
Okay. Going back all the way back to your time at the academy, did you participate when you were a recruit in what's known as a controlled drink or wet lab?
Yes, sir. I did attend one and participated in one.
Okay. Can you describe for the court what a controlled drink / wet lab is?
It's a controlled drinking program, which we law enforcement officers reach out to the public, request volunteers to come to the law enforcement academy, and we ensure that they have not consumed any alcohol prior to the start of this program. And throughout the night, we introduce alcohol in a controlled manner to these volunteers. They don't know what their, consumption is, the amount of consumption they've had, and the recruits or cadets have to administer standardized field sobriety tests to these volunteers and to make arrest or non-arrest decisions.
Okay. Is everyone who is from the public who is drinking, are all of them intoxicated?
No, sir.
Okay. Were you able to correctly identify those who were intoxicated?
Yes, sir. That's one of the requirements to get my certification for this class.
And on October 24th, 2020, were you certified in the administration of standardized field sobriety tests?
Yes, sir, I was.
Okay. And as an instructor for the state police, can you ballpark? Oh, I think we lost you on.
Sorry.
No, you're fine.
Okay.
I'll redo the question. So as a SFST instructor for state police, can you ballpark approximately how many times you've either supervised, participated, educated recruits throughout the state of New Mexico?
I think I, would say I have about 1,000 people that I've instructed since I've been an instructor till this day.
Okay. When did you become a standard or an SFST instructor?
I believe it was back in 2016. I became an instructor.
And since your time, I think that was 6 years ago in 2015, as a law enforcement officer in the state of New Mexico, approximately how many DWI investigations have you conducted?
DWI investigations that I've conducted, I would say easily over 600.
Okay. And in all 600 of those investigations, did you arrest every single individual?
No, sir, I did not.
And why not?
Every DWI investigation is different. Every subject displays different cues. So there's some that don't display enough, and they ultimately get a ride home, or you get to, go home.
Okay. And on October 24th, 2020, did the defendant in this case agree to take standardized field sobriety tests?
Yes, sir. She did to perform the standardized field sobriety test.
Okay. And can you describe for the court the conditions regarding the location where the standardized field sobriety test took place?
Yes, sir. It was southbound Interstate 25 near milepost 224. It was just south of the MLK exit. It was a flat paved surface, clear of any foreign objects. It was illuminated by my white takedown lights. There's also overhead lights on the interstate that also assist with illuminating the roadway. The weather was clear. I described it as clear. It was not windy, rainy, or snowing or anything like that.
And prior to the administration of these tests, or during the administration, did you ask the defendant about any medical conditions that would impair her ability to perform these tests?
Yes, sir. I did ask her about any recent head injuries, eye contacts, and any injuries to her legs or feet that are going to prevent her from walking a straight line, balancing one foot, or making a turn. Ms. Chavez stated no to all my questions and described herself as being healthy.
Okay. Can you tell the court what the first test you administered in this case was?
Yes, sir. The first test was that I administered was the horizontal gaze nystagmus test, to include the vertical gaze nystagmus test.
And can you tell the court what instructions you provided for the horizontal gaze nystagmus test?
Yes, sir. I requested her to stand with her feet together, her hands directly at her sides. I instructed her that she was going to remain in that position there until I was done administering the test. I informed her that she was going to stare at the tip of my right index finger with her eyes and not to move her head. She was asked if she understood the instructions given. She stated she did, so I administered the test to her.
Okay. And are these the same instructions you provided in roughly the 600 previous DWI investigations you've been involved in?
Yes, sir.
And without reference to eye movement, did you make any physical observations about the defendant while she was performing this test?
Yes, sir. I was able to administer the test to her. I just noted that she displayed a noticeable front to back sway as she performed the test, or as I administered the test to her.
Okay. So was she able to follow all the instructions you provided her?
Yes, sir.
What was the next test that you administered in this investigation?
The next test was the walk and turn test.
And what instructions did you provide the defendant regarding the walk and turn test?
Yes, sir. I requested her to stand with her feet together, her hands directly at her sides. I instructed her she was going to picture an imaginary line on the ground from where her left foot was, straight out in front of her to where I was standing, where my right foot was. After she was able to establish that imaginary line, I did instruct her or inform her that the line was going to be approximately the width of her shoe, which Ms. Chavez was wearing tennis shoe type shoes. I believe they're a black and white Nike tennis shoe type. After she was able to establish that line, I did instruct her that to put her left foot on that imaginary line, take her right foot, place it directly in front of her left foot, touching heel to toe. Keeping her hands directly to the side, and instructed her to remain in that position there until I was done giving her all the instructions and not to start the test. I informed her, when I do tell you to start the test, you're going to take 9 steps forward on this imaginary line. You're going to look downward at your feet, count each step out loud, touch heel to toe in each step, and keep your hands directly to your side at all times. I then informed her that I was going to be demonstrating the test. I took 3 steps, but reassured that she had to take 9. I informed her on her 9th step, she's going to leave that front foot planted on the ground with her opposite foot, which is her back foot. She was going to take a series of small steps to turn herself in the opposite direction, which then I demonstrated the turning sequence. And I informed her that she was going to take 9 steps back on the same imaginary line. And I demonstrated the second series by taking 3 steps, but we ensured that she had to take 9. I did inform her once she starts this test, do not stop until it's completed fully.
Did she, those are a lot of instructions. Did she appear to understand those instructions?
Yes, sir, she did. I asked her multiple times if she understood the instructions given and made sure she fully understood the instructions and demonstration before I had her begin the test.
And before we talk about her performance on this specific test, can you tell the court what validated clues or indicators you look for during the walk and turn test per NHTSA?
Your Honor,
Yes, sir, there's.
check
Oh.
the terminology.
Just a moment. I'm sorry, Counsel, what was that?
I said, I'm going to object to the terminology that the state is using regarding certified or validated clues under the circumstances. They haven't laid any foundation for any validation of any clues, how the validation work. That's a scientific analysis that is something that the state hasn't established, regardless of their solicitation of the officer's training. There hasn't been any foundation laid for any validated clues or anything like that. So under the circumstances, I'm going to object to the terminology. And it's part of what falls under that motion where it came to the officer laying foundation before testifying about certain things. And I think we've kind of hit that point right now where the state, while they've gotten his training and they've gotten his experience, they haven't laid any foundation for any validation of any clues. And I think that that's outside the scope of what they should be establishing here today.
Mr. Conlon, any response?
Your Honor, well, on two things, the state at this juncture was not going to go into how validation infers or makes conclusions regarding intoxication, regarding any studies or scientific data. The validation is a terminology used in NHTSA. Officer Lujan is a trained certified law enforcement officer whose training is based on the NHTSA manual. The state believes that using the term validation without going into any additional information at this time is appropriate, and that the foundation for this current juncture of questioning has been met.
Okay, and Mr. Rashid, any reply?
Yeah, to say that I'm not going to go into any of the validation or the basis for the validation, but I'm just going to use the term validation. I think that is kind of like saying defendant guilty, defendant guilty, defendant guilty. I'm not making any statements regarding the defendant's guilt, Your Honor. It's calling them validated adds authenticity to them, adds support to them, adds kind of a mental outlook that is different than if he just asks him what he asked her to do and what she did. I think that the court can make an appropriate determination today that way.
Parties, I have a fairly mixed ruling. On one hand, the state has not established what a clue is, much less a validated clue as it relates to the field sobriety test. The officer hasn't explained that as part of his training and experience for administering the tests. So to that extent, I will sustain the objection. The state is free to lay more foundation in that regard. As to the scientific nature of it, I think calling it validated is perfectly fine. I'll make the appropriate decision at that time, regardless of the state's characterization. But at this juncture, the state has not established what a clue is as it relates to a field sobriety test. So I will sustain the objection at this point.
Thank you.
Officer Lujan, can you tell the court, based off of your training and experience, what a clue is?
So law enforcement officers are trained to look for certain clues or cues in the DWI world. These clues have specific meanings to them. There's 8 validated clues per the NHTSA standards, which I'm trained on the NHTSA manual revised 2018.
Okay. And can you tell the court for the walk and turn what clues NHTSA has instructed you to look for?
Yes, sir. There's 8 validated clues per the NHTSA standards, and the 8 validated clues are 2 in the instructional stage, can't maintain balance while listening to instructions, and starting the test too soon. There's 6 during the walking stage, which lifts their arms from the side more than 6 inches, stops while walking, incorrect number of steps, improper turn, lifts their or misses heel to toe touch more than half-inch gap, and steps offline.
Did your training per NHTSA explain to you, and are you certified to testify on what does it mean that a clue is validated?
There's a lot of scientific stuff behind it.
Excuse me.
Sorry, Mr. Rashid.
The state is asking the witness for the basis for the validation at this stage, or are you asking about, I'm not sure that the question was in a correct form. Could you repeat it, please?
Sure. And Your Honor, for the record, the state will withdraw that previous question.
Okay, great. I was still trying to unpack that question myself. So why don't you go ahead and ask a new one?
Officer Lujan, you previously testified that you are trained off the NHTSA manual. Is that correct?
Yes, sir.
Are you certified in stating that there are validated clues per the NHTSA manual?
And certification, I think, is the term that I'm having issue with. Certified to testify, certified to administer, certified at all. Is there a certification that the officer has that should have been produced regarding this issue? He might have training, Your Honor. He might be authorized to be an instructor, but I don't think that he is in a position to testify to the issue that the state is requesting of him, and especially labeling it certified to testify. Nobody gets certified to testify.
Okay, so I'm going to allow the state to ask a question, but the question in the court's mind is who certifies and what is he supposed to do? The state can ask the question, but it doesn't really have much foundation or meaning without any background. I'll allow Mr. Conlon to ask the question, but he'll probably have to ask some follow-up questions as well.
Why does NHTSA ask? I'll withdraw that question, Your Honor.
Okay.
Why does NHTSA train you to look for certain things?
That's going to be kind of one of those things I can't answer. The reason for that is there's a lot of statistics behind it that go into play as to why those clues were specifically picked, and everything else. We as law enforcement officers are trained to look for those 8 certain clues that I just mentioned and named, and I can't tell you why somebody picked those clues out of those, like, hundreds of them. You know what I mean?
Do you need to observe all 8 clues that you previously mentioned to make an arrest?
No, sir.
What clues did you observe in this instance?
In this instance, for the Miss Chavez, I did observe 3 out of the 8 clues. The 3 clues that I did observe were she lifted her arms from her side more than 6 inches during the first series, and a little bit during the second series. She was observed stepping offline on step number 9 during the second series, as well as missing heel-to-toe touch more than half-inch gap on step number 1 during the second series. So I did note 3 out of the 8.
I apologize for going backwards a little bit. You mentioned you administered the horizontal gaze nystagmus test. Is that correct?
Yes, sir.
Okay. You previously mentioned you observed front to back sway. Can you tell the court why that stood out to you?
What do you mean how it stood out to me?
You previously stated that you observed during her performance of the horizontal gaze nystagmus test, you observed her to demonstrate front to back sway. Why did that stand out to you as part of your investigation?
We document what we observe as we're administering the test to them. We have them stand with their feet together, hands directly at the side. And the reason for that is it's one of those divided attention tasks. You're having a subject remain in a position that's not a normal position to be standing in. At that time, we want to see how they're controlling their body. So in this instance, Ms. Chavez displayed a noticeable front to back sway. And that's why I noted it, because I was there in person with Ms. Chavez.
Okay. After the horizontal gaze nystagmus test and the walk and turn test, what was the next test that you administered?
Upon the completion of the walk and turn test, I then proceeded to the next test, which was the one leg stand. test.
Can you tell the court what instructions you provided the defendant for the one leg stand test?
Yes, sir. Once again, I request her to stand with her feet together, hands directly at her side. I instruct her to remain in that position there and not to start the test. I instruct her to do so. I informed her when I do tell you to do so, you're going to pick the foot of your choice. It could be your left foot or your right foot. You're going to lift that foot approximately 6 inches from the ground. You're going to keep your foot parallel to the ground, your hands directly at your side and both legs straight. You're going to look down at your raised foot and you're going to count in upward manner by 1,000. Similar to this, 1,001, 1,002, 1,003, and continue counting upward by 1,000 until I instruct you to stop.
Did the defendant understand your instructions regarding the one leg stand test?
Yes, sir. I asked multiple times if she understood the instructions and demonstration. I made sure she fully understood and had no questions regarding the instruction or demonstration before I had to begin the test.
And are these the same instructions you previously provided in the roughly 600 or so DWI investigations you've conducted?
Yes, sir.
And what clues per NHTSA do you look for during the one leg stand test?
There's 4 validated clues that a law enforcement officer is trained to look for. The 4 validated clues are puts their foot down, uses arms to balance, sways, and hopping.
And what clues were present in this particular circumstance?
Yes, sir. As Ms. Chavez performed the test, she selected to lift her left foot from the ground. As she performed the test, she displayed a noticeable circular sway for a good majority of the test, and she lifted her arms from her side more than 6 inches. So I noted 2 out of the 4 clues.
In your honor, I believe the defendant in this case stipulated to the admission of State's Exhibit 1. Your honor, may the state have permission to publish State's Exhibit 1? If not, I'd be happy to lay down that foundation for this.
And Mr. Rashid, did defense stipulate?
Your Honor, I did stipulate with the exception of the portion of the video that would purport to show the horizontal gaze nystagmus test eye movement.
And Judge, as you are the finder of fact in this case, I believe the state's position is that you are able to discern admissible evidence as an inadmissible evidence, as this is a probable cause hearing. This is not a jury trial. You are trained to make decisions about what is admissible and what you can consider when coming to a conclusion of probable cause beyond a reasonable doubt for guilt.
Okay. Now, I'll be frank. Is there any portion of this video that shows her any eye movement that the officer, well, I guess he hasn't testified about anything, but does the video show any of that?
Yes.
I would say you would see her eyes moving. I don't believe anything to a non-certified law enforcement officer would be able to distinguish any clues per NHTSA regarding her eye movement.
Okay, and Mr. Rashid, did you say yes?
Yes, Judge, like he is standing in front of her, his finger is positioned and his body is positioned in a way utilizing his lapel camera or on body camera that clearly catches my client's face, eyes, and the administration of that test. That's why I had the discussion with the state in advance. That was the agreement, I believe, that we had, was that the horizontal gaze nystagmus portion of the test wouldn't be shown. So that's what would be our preference. And based on the evidence, testimony, objections, I believe that it would be appropriate for that portion to be skipped over.
Okay, and Mr. Conlon, what say you?
We did have a conversation about that. I specifically told defense counsel explicitly what I was going to argue, as you are the finder of fact and have the ability to decide what is admissible and inadmissible evidence, and that you'd be able to exclude from watching this video anything pertaining to her eyes. But my position is you are not trained in being able to detect any type of the clues per NHTSA of her eye movement.
I'm not sure that
Okay.
calling the court not trained to see something that has been described by an officer or described in other circumstances. And also, Mr. Conlon just took over this case. When I said that I spoke with the state, I spoke with a different assistant DA that is the one that tendered the exhibits to me prior to the last trial setting, which was continued. So Mr. Conlon and I's discussion regarding that was just that. It was something that happened today, not prior, and he just took over this case. So the stipulation was made with the assistant DA that was handling this case for the trial. It was scheduled, I believe, on the 13th of May, if I'm not mistaken.
All right. So parties, it doesn't sound like there is a stipulation to State's Exhibit 1 based on those prior conversations. So State, you will need to lay foundation for State's Exhibit 1. As to the horizontal gaze nystagmus, there hasn't been any testimony in this trial about eye movement or what eye movement means. And I haven't been trained in anything like that, but in all candor, as it bears on the facts of this case, there's been no testimony about what any eye movement means. The only testimony about the horizontal gaze nystagmus would be about the defendant. The officer testified that she was perceived to be swaying backward and forward. That would be the only thing the court would be looking for. So I don't really see any reason to strike that, but at this point, it doesn't sound like there's a stipulation. So Mr. Conlon, you will need to lay foundation for State's Exhibit 1.
Not a problem. Thank you, Judge. Officer Lujan, did you have a recording device on your person on October 24th, 2020?
Yes, sir, I did.
And what was that device?
It's a WatchGuard camera system. It's a lapel camera that's on my person that captures everywhere I go.
Okay. And were you able to record any part of your investigation with that recording device?
Yes, sir, I was.
And at the conclusion of your investigation, what did you do with that recording?
The video was uploaded to our WatchGuard camera system, as well as it was able to get dispersed for documentation purposes.
Okay. And Judge, as this is a virtual hearing and not an in-person one, rather than providing a physical exhibit to Officer Lujan, may you please turn around so I can play a portion of the lapel video.
Oh, you want?
That's
Okay.
That was the preference in my previous court, Your Honor, is to, for authentication purposes, the judge would just turn around as to not see anything that was inadmissible. If Mr. Rashid doesn't have an objection to it, I would say you don't need to turn around. I was just trying to ensure that the rules of evidence were followed when it came to laying foundation.
Sure. I've not left the room. I mean, I usually just step to the side if you're refreshing someone's memory. But if you're just playing a few seconds of it, usually I sit here and then we all see what the officer sees and whether or not he knows that that's what it is.
The first minute and 30 seconds, Your Honor, the lapel video does not capture any visual thing. It's covered by a seatbelt. It's the state's belief. And so the state would be asking to play approximately about 1 minute and 45 seconds so that a picture or a frame of some description could be shown to the officer so he could authenticate it is what he says it is.
Okay, go ahead.
I don't object to that, Your Honor.
I'm sorry, what was that?
I said I don't object to that. I agree with Mr. Conlon that the first over 1 minute is just black.
Okay. All right, go ahead, Mr. Conlon.
If I just may have 1 second, Judge, so I don't mess up the Zoom technicalities.
Judge, did they have Zoom trial practice when you were in law school?
No, we barely had Wi-Fi at the law school.
Yeah, we didn't have computers, so.
And if Mr. Rashid, I guess, would you allow me to jump at least 30 seconds? So
Yeah, go up to where there's video that he can authenticate. It's on.
And Officer Lujan, do you recognize what has been marked and is shown to the court as State's Exhibit 1?
Yes, sir. This is going to be my lapel from my chest of my patrol unit. I could tell because I basically live inside my patrol unit nowadays.
And prior to today's hearing, have you reviewed your lapel video in preparation of this hearing?
Yes, sir, I have.
And is what I'm playing for court an accurate copy of the video that you recorded on October 24th, 2020?
What you played so far, yes.
Judge, based off of the foundation laid by the state would move to admit what's been marked as State's Exhibit 1 into evidence.
In defense, any objection?
No objection, provided the limitation that I had objected to earlier regarding the HGN, Judge.
Okay. So
I'm okay
parties-
with him just playing it. If the court's going to ignore any purported eye movement that might happen based on the lack of testimony, I'm okay with that.
Yeah, based on that lack of testimony, I'll be clear that eye movement is not going to be considered in my decision today. With that understanding, State's Exhibit 1 is admitted into evidence.
And Judge, the state had permission to publish the remaining portion, approximately 13 minutes and 7 seconds of State's Exhibit 1.
Okay, go ahead.
Thank you.
How's it going? Yes, ma'am. How you doing? I'm Officer Lujan with New Mexico State Police. You understand the reason why I'm stopping you? You can roll that out there. Oi. How you doing? Good. I'm Officer Lujan with New Mexico State Police. You understand the reason why I'm stopping you? No, it was actually the speed. You passed me at 89 miles an hour. Okay? Do you have a driver's license, insurance, registration? Thank you, Ms. Chavez. Do you have insurance? I tend to lose those. Travis, what I'm gonna have you do, ma'am, is I'm gonna have you step on out just real quick. I just have to ask a few questions, okay? Any weapons, knives, guns, anything I need to know about? Okay, just be careful when you open your door, okay? You can just sit tight for me, please. Thank you, sir. I appreciate it. Go walk to the front of my unit for me, please, Miss Travis.
Of course.
Where are you coming from, Miss Travis?
Work.
Work? Where do you work at?
Left Turn Distillery in Palmersburg.
Okay, very nice. What's up with the
Yeah.
rush? Why are you going so fast?
I was just trying to merge on from Comanche, so people are just kind of going pretty fast. I apologize about that. It's just kind of.
Okay.
Oh,
Officer Luna, I do have a question. I guess, what would you consider the merge lane for Interstate 25 southbound and exit 227? What lane number would that be?
In that area, it's going to be around number 4 to merge on, because there's 3 straight, and that's at that time it's starting to get where it's congested with the Big I approaching. So I know there's like 5 or 6 lanes in that area.
Okay, thank you.
weird place to kind of merge because it's right before I-40, so people are kind of going fast. And
Okay, Ms.
I kind
Tucker.
of expected you to pull me over, honestly.
Yeah, I appreciate
As
the
soon as I
honesty.
passed you, I'm like, yep, we're gonna.
Most
I
likely,
asked him
right?
to get my registration, of course. Yeah.
I got you. Ms. Chavez, is this your current address?
It sure is. Yeah.
It is? Okay, when was the last time you were pulled over?
I'm sorry. Well, I want to say about a year and a half ago.
Year and a half?
I was going home from work again at like 2 in the morning. So it's down in Peralta where I live. I believe that one is Rancho Vecino.
Mm-hmm.
So currently I am in Peralta.
Peralta?
So
So you're headed all the way down towards Los Lunas area?
I am, yes.
Okay. Miss Chavez.
Yeah, so just getting off this late kind of.
Got you. Miss Chavez, how much have you had to drink tonight?
I have not had any drinks. I think I had a shot probably about 7 o'clock.
Okay, the reason why I'm asking is I can smell it. So that's why I'm asking.
Yeah, it is
Okay.
at like
So you
7
had one
o'clock.
shot?
I did have one shot and one beer.
One shot, one beer?
Yes, sir.
Okay, and your last drink was what time?
I think I finished off about 10.
Okay.
Yeah.
Okay, well, thank you for the honesty. Have you had any
Of
recent head
course.
injuries?
No, sir.
Do you wear eye contacts, Miss Chavez?
No, I do not.
What I'm gonna have you do is I'm gonna have you stand right here for me, please.
You got it.
Facing me. Go and put your feet together just like mine. Hands directly at your side. I'm gonna need you to remain in that position there. Do you understand?
You got it.
I'm gonna have you stare at the tip of my right index finger with your eyes and do not move your head. Do you have any questions?
No, sir.
Okay, just keep your hands directly at your side
Is
for me,
that your
please.
tip of your finger?
Yep, right here. You see my finger? Just follow my finger with your eyes and do not move your head. Do you understand?
You got it. Sorry.
No worries.
Mo, the wind is kind of.
You can move your hair.
Thank
I
you.
can see that it's kind of bugging, okay? Just follow my finger and continue where I left off, okay? Miss Chavez, I'm gonna go upward now, okay? Just follow my finger, please.
Am I allowed to think?
Yes,
Okay,
ma'am.
just making sure.
Yes, ma'am. Thank you. Okay, Miss Chavez, do you have any injuries to your legs or feet that are going to prevent you from walking in a straight line, balancing
I
on one
do
foot, and
not.
making a turn?
No, sir.
Completely healthy?
Completely healthy.
Are those shoes comfortable to walk in?
They pretty are.
Okay. If you want, you can start rolling up your pants so you won't step on them, okay?
If you don't.
That's fine. I'm going to have you stand over here. I'm gonna have you stand right here on the back of my unit a little bit, okay? Five 4-8 income.
548.
Clear for Orlando, New Mexico.
Go ahead, please.
It's gonna be 513-213-387. It'll be 10-6 fields.
Negative 9, Miranda Chavez, Valentine Davis. 10-6 field, 23.
Okay, Miss Chavez, I'm gonna have you stand over here for me, please, okay? I'm gonna have you facing your truck.
Okay.
This is a paved surface. It's clear of any foreign objects. There's nothing that's gonna twist your ankle or harm you in any way, correct?
Correct.
Okay, Miss Chavez, what I'm gonna have you do is I'm gonna have you put your feet together just like I am, still facing this way. What I'm gonna have you do is I'm gonna have you picture an imaginary line on the ground from where your left foot is, straight out in front of you to my right foot, okay? Can you see this straight line? Yes or no?
Yes, sir.
This line's gonna be approximately the width of your shoe. Do you understand that?
Okay.
Okay, Miss Chavez, what I'm gonna have you do is I'm gonna have you take your left foot, place it on that line, take your right foot, place it directly in front of your left foot, touching heel to toe, standing just like I am. Go ahead and get in this position for me, please. Hands directly at your side. I'm gonna need you to remain in that position there until I'm done giving you all the instructions. You're not gonna start the test till I tell you to do so. Do you understand?
Yes, sir.
So not till I tell you to do so, you're gonna take 9 steps forward on this imaginary line. You're going to look downward at your feet, count each step out loud, touch heel to toe on each step, and keep your hands directly at your side at all times. Do you have any questions? Completely understand. So I'm going to demonstrate the test. It's going to look like this, ma'am. 1, 2, 3. Continue all the way to 9. Yes, ma'am. I'm only going to take 3 steps. You're going to take 9 steps. Do you understand?
Yes.
On your 9th step, your front foot's going to stay planted on the ground. With your back foot, which is your opposite foot, you're going to take a series of small steps, just like this, to turn yourself in the opposite direction. You see I turned around?
Yes, sir.
Now you're going to be facing the front of my patrol unit. You're going to proceed back 9 steps in the same line, like so. 1, 2, 3. Once again, continue all the way to 9. I took 3 steps. How many steps are you going to take?
9.
Once you start this test, you cannot stop until it's completed fully. Do you have any questions? You completely understand everything, Ms. Travis?
Yes.
Keep your hands directly at your side and go and begin, ma'am.
Does it start with 1?
The first step will be with your left foot.
Your left.
Yes, ma'am.
Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9. Proceed. 3, 1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay, Ms. Travis, go and face me for me, please. Put your feet together just like mine, hands directly at your side. Ms. Travis, I'm going to need you to remain in that position there. You're not going to start the test till I tell you to do so. Do you understand?
I
So
see.
not till I tell you to do so, you're going to pick the foot of your choice.
Okay.
It could be your right foot or it could be your left foot. You're going to lift that foot approximately 6 inches from the ground.
Okay.
You're going to keep your foot parallel to the ground. Your hands directly at your side, both legs straight. You're going to look down at your raised foot and you're going to count in an upward manner by 1,000. Similar to this, 1,001, 1,002, 1,003, and continue counting upward by 1,000 until I tell you to stop.
Okay.
Do you have any questions?
No, sir.
You completely understand? So I'm going to demonstrate this test. It's going to look like this, ma'am. I'm going to pick my right foot for my demonstration, but you can pick your right or your left. You understand? You're going to lift that foot approximately 6 inches from the ground. You see how I'm doing it?
Yes,
Keep your foot parallel. Don't point it up. This is parallel.
Okay.
Hands directly to the side, both legs straight. Look down at your raised foot, and you go ahead and count in an upward manner by 1,000. Similar to this, 1,001, 1,002, 1,003, and continue counting upward by 1,000s until I tell you to stop. Do you have any questions?
No.
Completely understand everything, Ms. Travis.
I understand.
Go and begin, ma'am.
1,002, 1,003, 1,004, 1,005, 1,006, 1,007, 1,008, 1,009, 1,010, 1,011, 1,012, 1,013, 1,014, 1,015, 1,016, 1,017, 1,018, 1,019, 1,020, 1,021.
Go and stop, Ms. Travis.
And Officer Lujan, I'm going to stop it right there momentarily and ask a couple more questions. Okay.
Yes, sir.
Did your investigation end after that last test?
No, I did have a conversation with Ms. Travis. That,
Okay.
questioning. Yes, ma'am.
Okay. Before we get to that conversation, based off your training, how many, if any, clues do you need to observe in any 3 of the tests to determine if you have probable cause? Is there a specific number?
No, there's not a specific number.
Also,
Obviously,
if you're saying something, you're on mute.
I'm sorry. I'm going to object to that question, Your Honor. Asking how many clues it takes and how many clues are necessary includes the testimony regarding the HGN and the eye movement. So asking that question in that fashion that includes the HGN and the clues involved in the HGN is totally inappropriate given the court's ruling, the arguments that have been made regarding eye movement, regarding the evidence. So asking that question in that fashion when the state hasn't either for their choice or the law put on all of that other evidence regarding HGN. I don't know that they can ask that question and ask the officer to testify regarding the clues on the HGN and how many matter.
Okay, Mr. Conlon, a response.
Judge, Officer Lujan, prior, I guess, partly through Mr. Rashid's objection because he was on mute, the state elicited there's no specific number of clues. That was, the state's not going to go into the meaning of the clues in terms of any validated studs or anything like that. It was just, does NHTSA require to have X amount of clues for Officer Lujan in any given case to make an arrest?
Okay. All right.
This goes to the totality of the circumstances for probable cause.
Okay. Well, I understand the concern from defense. I'm going to overrule the objection at this point in time. He can answer that question as asked.
So, Officer Lujan, I believe you're stating in response to my question, is there a specific number of clues you're required to observe to have probable cause?
No, sir, there's no specific amount of clues.
And at the conclusion of the standardized field sobriety test, are you required in that specific instance to make a determination of probable cause?
It's based off the whole totality of the circumstances. So, I mean, not specifically once the standardized field sobriety tests are completed, we have to pull handcuffs out and make the decision right then and there. It's not a split-second decision. We have the right to further questioning. It's not until we pull the cuffs out and ultimately that's where the investigation is concluded at that time.
Okay. And you mentioned further questioning. Did further questioning take place in this specific investigation?
Yes, it's not questioning. It was more or less just a conversation and to see how the answers will, come out with Ms. Chavez. She was respectful the entire time.
Okay.
So
granted that she was respectful, can you tell the court what question or what conversation you had with the defendant after the conclusion of the 3 tests we just observed?
The conversation was more or less how she feels and if she feels like she should be driving. And it was more or less I asked questions about her male passenger, if he's been drinking, stuff in that nature as well.
Okay. Do you recall her specific response to how she felt about if she should be driving?
She did respond to my question. She advised that she believed that she could make it home. But she also did inform me that, if I felt it was necessary, that she will drive her vehicle off the roadway onto the next exit and basically call somebody to come pick her and her vehicle up.
Okay. Did she explain why the passenger couldn't drive home?
She did advise that the passenger actually was drinking a lot more than she was, that he showed up to her work for like a dinner date type thing, to see her for dinner and something in that nature, but he was drinking more than she has.
Did your lapel video capture this conversation?
Yes, sir, it did.
Your Honor, the state requests permission to, I guess, continue to publish State's Exhibit 1.
Granted.
Ms. Chavez, you said you had 2. One
sure
shot,
did.
1 beer.
Yes, sir. Right
Okay.
after work.
Right after work.
I sure did.
Okay, Ms. Chavez, listen, how do you feel right now? You think you should be driving?
I believe I could make it home. I
feel-
do. But I believe if you feel like I need to, I will definitely pull off and we will definitely get an Uber if you feel the need to with this test. But I did only have 1 shot and 1 beer. My boss doesn't let me drink until after we're off shift.
Ms. Chavez, it's just one of those things. It's very close. You have a long way home.
Yes, sir.
You understand that?
I'd have to get through Isleta and Belen or Bosque Farms.
How much does he have to drink?
He can't drive home.
He can't drive home?
No, sir.
Why is that?
He was drinking prior,
Okay.
so that's why I am drinking. But we would be more than happy.
That's
to
why
leave
you're
my
drinking?
Vehicle. What?
That's what you said. That's why you're drinking.
I was drinking because I was off my shift. He had visited me for dinner.
Well, I'm just asking why he didn't drive, and that's why you explained he had too much to drink.
He did have too much to drink.
And honestly, I think you had too much to drink as well. I don't think you just had 2.
So, Officer Lujan, I guess, can you explain again to the court, and I believe this is probably me asking some poor questions, Why did her response stand out to you?
Her response initially, as I said, you've had one beer, one shot, and then her response was, yes, it was after work. So it changed from the initial time that she told me 7 p.m. and then 10 p.m. That changed. The fact of the matter is, she did say, that she believed that she can make it home, but ultimately it was like, well, if you feel like I should pull off, I will pull off and call for an Uber. That's ultimately is concerning. The fact of the matter is, even though we're having this conversation and we're doing all the standardized sobriety test, she still is over here saying that she will get behind the wheel, pull off, and then ultimately call an Uber. It was not more or less like, hey, I will call somebody right now and have them pick me up from here. And then ultimately the fact of the questioning about the male subject drinking, she did inform me, he had a lot more to drink. And that's why I was drinking, which her statement is, that's why she was driving. That was kind of conflicting and concerning as well.
And after that conversation that we just saw via State's Exhibit 1, did you form an opinion about the defendant's condition, intoxication, or ability to operate a motor vehicle?
Yes, sir.
Your Honor, I'm going to object to the statement of that opinion under the circumstances. We, I think, have danced around the whole clues, and then the state has asked about the number and whether there's a number. And now we are at opinion testimony. I don't believe that under the circumstances, it's appropriate for the officer to state that opinion at this time.
Judge,
And is there any additional arguments that you want to make, Mr. Rashid?
No.
Okay, and Mr. Conlon, any response?
Judge, if Mr. Rashid would want to argue, I guess, more in depth his motion in limine, the state would just request that Officer Lujan be placed into a breakout room so that the defense and state then, I guess, could articulate via case law the position that prohibits the officer, or at least defense's position that prohibits the officer from forming a lay opinion testimony about the defendant's ability to operate a motor vehicle safely.
Okay. I mean, I asked him if he had any additional argument, and he said no. So I think we can go ahead and I can just make my ruling. So parties, after reviewing the written motions and the case law cited and hearing the testimony of Officer Lujan, the court will accept the opinion as a lay opinion. I don't find that this is expert testimony. I do find that this is a lay opinion, and it will be given the weight it deserves as a lay opinion. With that, Mr. Conlon, please move ahead.
And Officer Lujan, just for the record, I'll re-ask the question so it's clean. What, if any, opinion did you form about the defendant's condition, intoxication, or ability to operate a motor vehicle safely that night?
Yes, upon the completion of the standardized civil sobriety tests, based off the whole totality of the circumstances, her statements that she provided me, my observations, her omissions, I observed her to display signs of impairment and determined she was no longer able to continue operating a motor vehicle. So Ms. Chavez was arrested at 11:25 p.m. for driving while under the influence of intoxicating liquor and/or drugs.
And Your Honor, for the purposes of the probable cause hearing, the state passes the witness to defense counsel.
And Mr. Rashid, is there any cross-examination?
Yes, Your Honor, but what I'm going to ask, it's 3 o'clock currently, and we've been kind of here for about an hour and a half. I'm going to ask that we take a brief recess to use the restroom before we proceed with cross-examination, if that's okay.
Sure, no problem. Let's reconvene at 3:10.
Thank you.
Thank you, Your Honor.
Sure. Okay, everyone, let's go back on the record in State of New Mexico versus Miranda Chavez, T4DW 2020-1613. All of the parties are present. And Mr. Rashid, are you ready for cross-examination?
I am, Your Honor. Thank you.
Okay.
Officer Lujan, how are you this afternoon?
Good afternoon, Mr. Rashid. How you doing?
I am alive. All right, so I guess I'm gonna have to do this a little bit the way the state did in terms of the manner of questioning regarding, we'll just have to do the video portion at the end, okay?
Yes, sir.
So I'm just gonna go through general questioning first, and then we'll get to the video, okay?
Yes, sir.
So one thing that I would like for you to testify about is you testified that my client was doing 89 in a 65, I believe. Is that right?
Yes, sir.
And you were watching her in a rear view mirror, a side mirror, or what were you watching her on?
It's going to be my side mirror, my driver's side mirror, as she was approaching from the rear to my patrol unit.
All right. And as she was approaching the rear of your patrol unit, did you notice anything else about her driving that was illegal?
No, sir. Like I explained, just observed her, closing distance very quickly.
Right. But I guess I'm asking you, did she fail to maintain her traffic lane at any point?
No, sir. I didn't note that.
Did she, well, based on your visual contact with her, did she signal every motion that she made from one lane to another to pull over, any of that?
After she passed my vehicle, yes, she did signal her right turn signal just to make lane changes. So yes, sir.
Now, you were asked a ton about your training and NHTSA, right?
Yes, sir.
And you are familiar with what are called visual cues, correct?
Yes, sir, I am.
Could you tell the court what visual cues are under your training pursuant to NHTSA?
Yes, sir. Visual cues, is stuff that could happen that will lead to other stuff. According to the NHTSA standards, there's multiple cues that law enforcement officers are trained to look for.
All right. And those are mistakes that people make while they're driving that have some correlation to DWI, right?
Correct. Yes, sir.
All right. And there's a pretty extensive list of them, I believe you have acknowledged, right?
Yes, sir. There's multiple.
Okay. And they include problems in maintaining proper lane position, correct?
Correct.
And those include weaving,
Yes, sir.
weaving across lane lines,
Yes, sir.
straddling a lane line,
Yes, sir.
drifting,
Yes, sir.
swerving,
Yes, sir.
almost striking a vehicle or other object,
Yes, sir.
and turning with a wide radius or drifting during a curve, correct?
Correct.
And my client didn't exhibit any of those visual cues, correct?
No, sir. She did not.
Now, there are some that are considered related to vigilance problems. Those include driving without headlights at night.
Objection, Your Honor.
Correct.
I'm sorry, what is the objection, Mr. Conlon?
It appears that Mr. Rashid is reading facts not in evidence. The NHTSA manual has not been submitted into evidence. I recognize he's asking questions about Officer Lujan's training, but given his reading of appears to be assumed lengthy long list, the state's objection would be that the facts are not in evidence, that the manual itself is not in evidence, so reading off the manual is inappropriate.
Okay, Mr. Rashid, any response?
Your Honor, I think it's entirely appropriate for me to ask the officer questions about his training materials and what he's trained to look for, given the million items that the state asked him about that he was trained to look for, and visual cues and clues on the test and cues on the test and things on the test that aren't cues and clues. So under the circumstances, me going through the officer's training materials, him acknowledging that that's what his training materials say, is directly relevant to this trial, and it's directly relevant to what the state is attempting to prove. I don't believe that the state's objection is sustainable, honestly.
It's okay. I'm going to overrule the objection. The officer testified about the NHTSA manual. It's not being offered into evidence, and counsel is free to use any sort of treatise like the NHTSA manual in cross-examination. The manual itself is not coming into evidence, but counsel can use it. And so with that, I'll overrule the objection.
Thank you. So Officer Lujan, there are cues related to vigilance problems, correct?
Yes, sir.
And those are driving without headlights at night,
Yes, sir.
failure to signal a turn or lane change, or signaling inconsistent with actions,
Yes, sir.
driving in opposing lanes or the wrong way,
Yes, sir.
a slow response to traffic signals,
Yes, sir.
a slow response to your signals,
Yes, sir.
and stopping in a lane for no apparent reason.
Yes, sir.
Then there are some cues that they say are related to judgment problems, correct?
Yes, sir.
Following too closely,
Yep.
improper or unsafe lane change,
Yes, sir.
illegal or improper turn,
Yes, sir.
driving on other than the designated roadway,
Yes, sir.
stopping inappropriately in response to an officer,
Yes, sir.
inappropriate or unusual behavior,
Yes, sir.
or appearing to be impaired.
Yes, sir.
Now, there are cues that are related to speed and braking problems, correct?
Yes, sir.
One of them is stopping problems, which says too far, too short, or too jerky.
Yes, sir.
Accelerating for no reason.
Yes, sir.
Varying speed,
Yes, sir.
and a slow speed.
Yes, sir.
So isn't it true that that comprehensive list of things that officers are trained to look for that ultimately have some correlation to DWI doesn't include a person that's doing 89 and a 65?
No, sir. I mean, what you just read off, no.
Is there something that I'm missing when it comes to those visual cues?
No, just based off my training experience within the last 6 years, but nothing off the NHTSA manual that you just read, sir.
All right. So there are also several post-stop cues that you're trained to look for, correct?
Yes, sir.
And difficulty with motor vehicle controls,
Yes, sir.
difficulty exiting the vehicle,
Yes, sir.
fumbling with a driver's license or registration,
Yes, sir.
repeating questions or comments,
Yes, sir.
swaying, unsteady, or balance problems,
Yes, sir.
leaning on the vehicle or other object,
Yes, sir.
slurred speech,
Yes, sir.
somebody being slow to respond to you, or that you have to repeat questions,
Yes, sir.
providing incorrect information or changing answers,
Yes, sir.
and an odor of alcohol.
Yes, sir.
So which of those would you say that she exhibited in your contact with her?
I would say the odor of alcoholic beverage, both inside the vehicle, outside the vehicle. The leaning against the vehicle, not so much. But when I told her, roll up your pants before the walk and turn test, she kind of just stayed right there, had, leaned a little bit against my unit. The changing of answers, that was obviously a concern for this incident as well.
And when you say changing of answers, I'm assuming that you mean when you asked her if she'd had any drinks tonight, right?
Yes, sir. That
And
was
then she said no, she hadn't had any drinks,
correct.
but she'd had a shot and a beer.
Yes, and that's she changed it. Yes, sir. Initially.
Well, you know what she does for a living, right?
She stated she worked at a distillery. It doesn't specify where she or what she did there, but yes, she worked at a distillery.
She said that she was a bartender, right?
I'm not too sure. I would have to refer to the video, but
Okay. And if you work in a bar, a drink, a beer, and a shot are three different things, right?
I never worked in a bar or distillery or anything, so I wouldn't know. A drink is a drink. If I have a drink of water, it could be from a bottle, it could be from a cup. I can't tell you that.
Well, I guess my point is that she didn't say, no, I haven't had anything to drink. And then you do some testing and ask her again, and then she changes. And then you do some more testing and you ask her again and she changes. It wasn't that situation, was it?
I asked her if she had how many alcoholic beverages she consumed. She initially stated
You
no.
didn't use that terminology, did you, sir?
I believe I did. I believe I asked any alcoholic beverages or drinks. It might have been drinks. But I know I asked in the mindset of alcohol there at the second time I asked right after the standardized full sobriety test.
In the initial questioning regarding alcohol consumption, you said, how many drinks did you have? She said none, but I had a beer and a shot in the same conversation, right?
Yes, sir. Something in that nature. Yes, sir.
So you considered that an inconsistent response, but now it might not be so inconsistent, right?
Well, I could still consider it inconsistent due to the fact that she initially stated no and then ultimately advised a shot and then a beer. Because I asked her about, you only have one shot. She said yes. And then she goes, and one beer. So it also changed there.
Okay. So out of all of the visual cues and the post-op visual cues, the two things that you're saying she had was an inconsistent response and an odor of alcohol.
And I advised about the leaning against the vehicle when she rolled up her pants. It was not like a full lean, but she didn't have, her body against my patrol unit.
So you are the one that suggested that she roll up her pants, correct? Before she does the field sobriety test?
Correct.
Why?
Because her pants were actually it was kind of like a bell bottom type style. So they're kind of flared at the bottom. So the way it was, you could see that she could have possibly stepped on them. So that's why I requested her to, roll them up.
Okay. When you asked her to roll them up, did you say anything about, well, don't put your behind on my vehicle while you do that, or don't?
No, sir, I didn't tell her
Anything?
that. No, sir. No.
Okay. All right. So she passes you on the highway and you engage your emergency equipment, right?
Yes, sir.
And how did she respond to your emergency equipment?
She braked, ultimately over to the right. I didn't document like delayed response or anything like that.
That's because she didn't have one, right?
Correct.
So you engage your emergency equipment. She pulls over to the right and stops as you would expect and require, correct?
Yes, sir. I didn't dock anything else.
Okay. So you approached on the passenger side. Why?
I approached on the passenger side because we're on the interstate, consistent with my training experience, and we're trained to do passenger side approach first, and then ultimately, if we have to, we can do driver side approaches.
All right. And when you approached the vehicle and requested the documents, how were those documents provided?
The documents were provided. Ms. Chavez did present me with her driver's license, and I believe the male passenger had all the vehicle documentations ready for me to present. And I gave them back to him because I tend to hold on to them and forget about them. So.
All right. So they were actually ready with all three documents when you approached the vehicle, correct?
Yes, sir. I believe they were.
That's something that you are trained to keep track of, right? If a person struggles, if you ask for the three documents and they only provide you one or two, you're supposed to note that, right?
Yes, sir. If we mean, that's what we're trained to look for. It's not always present, but yes, that's what we're trained to look for.
All right. So that's another thing you're trained to look for that wasn't present in this case, right?
Yes, sir. Like I said, every DWI investigation is a little different.
All right. And when you requested that she exit the vehicle, that's something that you're trained to observe as well, right?
Yes, sir. There's some cues that we're able to look for.
And what type of cues are you able to look for about a person's exit?
There could be exiting the vehicle with the seatbelt still on, vehicle still in gear, them having to hold on to the vehicle as they exit, lean against the vehicle as they're walking to the rear of it, stuff like that in that nature.
All right. And none of those things were present in this case either, right?
Not in this instance. I didn't document anything. I'm kind of vertically challenged. I'm a little short. The truck was a little bit taller. So by the time I was able to walk around, she was already meeting me at the rear of the vehicle. So I didn't document anything that I didn't see.
And you asked her to exit the vehicle, be careful with the door because she is on the edge of the freeway, right?
Correct.
And she did all of that.
Yes, sir. I mean, we didn't have any incident, which was a good thing.
Okay. So at this point, you decide to have a conversation outside the vehicle, right?
Correct. Yes, sir.
And you ask her why she was speeding.
Yes, sir.
So she tells you it's late, she's getting home, whatever, kind of the typical things that you might hear, right?
Yes, sir. Some of the
Okay.
common reasons.
And she indicated that she works at a distillery, right?
Correct.
And indicated that she'd had one shot, one beer, sometime between 7 and 10, according to the testimony today.
The initial, yes, sir.
Okay. So, you were asked about, kind of like that field sobriety tests are supposed to simulate driving, right?
Yes, sir.
And that people have to control the mental and physical components of driving too.
Yes, sir.
All right. And again, my client didn't exhibit any of the visual cues that officers are trained to look for in making DWI related stops, right?
Yeah, we're trained to look for them. It's not required, but yes, we're trained to look for them.
Yeah, I'm not saying you didn't have the right to pull her over for speeding. I'm just saying speeding by itself isn't one of those cues, correct?
Correct. Give me 1 second. I'm sorry, Mr. Rashid. My dogs are going crazy.
Judge made Officer Lujan be, I guess, allowed to be put on pause while he deals with his dogs.
Yeah, that's okay.
Probably not something that Mr. Conlon ever expected to be asking a judge in a trial.
No, you know, last year I was quarantined a few times and my cat and dog made regular appearances in preliminary hearings.
I heard
It's
one
just-
trial where one of the lawyers had roosters crowing in the background the entire time. That was fun.
It's been a weird year.
Yes.
It has. Thank you, Your Honor. I'm sorry about that.
Okay, Mr. Rashid, please continue.
Okay. So, and you were asked also, it's okay. Do you need to get up and go deal with it? Or I don't care if you need to, and I don't
Oh,
know.
you're good. Just
Okay.
my.
Okay,
Sorry, we have
What kind of
UPS knocking the door. We're all good now. Hopefully.
I don't believe there's a record anywhere that says objection, the dog is barking, Your Honor.
great.
Okay. So you were asked about the conditions of the area that you conducted the field sobriety tests. And you said that it was on the side of I-25, the lighting was good, it was clear, and it wasn't windy.
Correct. Like New Mexico winds. Yes, it wasn't windy like that.
New Mexico winds. Well, there was wind that night, and you can see it moving around her hair pretty comfortably that night, right?
There was a breeze. Yes, sir. Hair is a little bit light, so it will blow, but it wasn't like super gusty winds like we're used to here in New Mexico.
All right. And you testified that you inquired about medical conditions.
Yes, sir.
Why did you indicate in your report that my client had head injuries?
Judge,
Excuse me?
Mr. Coughlin?
I guess the police report's not in evidence. And I'm not sure not sure what role that would play in impeachment in this particular instance, as Officer Lujan has never testified to what he wrote about in his police report, and only testified to what he's recalling from independent memory in the video that we just saw.
Mr. Conlon just came up with an answer for Officer Lujan, not a question. The circumstances are Officer Lujan testified that he inquired about medical conditions, no head injuries, that she was perfectly healthy. And my review of his report shows that it says that there were head injuries. I'm allowed to ask about that. It doesn't have to be in evidence. The report doesn't have to be in evidence or admitted in evidence for me to ask him about his police report, no more than the state would walk up to him 50 times and show it to him in trial without ever putting a sticker on it and asking that it be admitted, Your Honor.
So parties, I'm going to overrule the objection. Counsel can ask about any inconsistent statement, regardless of whether that statement has been admitted into evidence. Please proceed, Mr. Rashid.
So, Officer Lujan, do you remember indicating that she did have head injuries in your police report?
So I know there is a kind of a topic in my HGN portion of my report. It says head injuries, yes or no. That could have been a typo where I forgot to change to no. But normally if they do say yes, I will document what their head injury is. And I believe in this instance, there says none reported. But yes, it could probably just be a typo error on my part.
Would that be a typo error where, okay, well, I'll just pull that question and rephrase it. When you do reports, do you start with a blank document?
Not always. The reason for that is we have a template that we follow to make sure we're capturing everything that, my investigation is going to cover. So there's some times where the check boxes get left yes rather than changed to no.
And that's similar to things like in your complaint where you refer to her as he.
That's a possibility as well.
So you take these reports and these documents and you basically write over them. You use what you can use. You leave certain things in there that you're going to put in every report, right?
Basically, it's kind of the template that we utilize. We go in there and we change everything else. Sometimes, like I said, I work a lot of hours. I get tired. I'm human. I make mistakes. So those are the possibilities where some of those he to she or she to he kind of get left out, yes to no. But the facts are there.
All right. So during your administration of the horizontal gaze nystagmus test,
Yes, sir.
you testified that she followed your instructions, correct?
Yes, sir.
And you have, as part of your report, kind of like, again, a list of questions or things that you observed that are totally separate from eye movement, right?
Yes, sir.
Now, one of those is that you ask or you have a indication regarding noticeable sway left to right, front to back, or circular.
Correct.
And you marked front to back in this case, right?
Yes, sir.
Not to move their head, yes or no, total times, and that was 0, correct?
Correct.
reminding her to look at your finger is something that you have in your report that you are trained to pay attention to. And in this case, you didn't have to remind her to look at your finger, correct?
Correct.
And to even follow your finger, which is another kind of thing that you can tell somebody while they're not doing the HGN correctly.
Correct.
She didn't have any issues with following your stimulus either, did she?
She did not.
I noticed that you testified that she was wearing sneakers, but in your report, you say that her footwear was removed, correct?
Yes, in this instance, same concept, typo. Ms. Chavez never removed her shoes. It remained on the entire time.
So far, we've kind of got 3 mistakes that we've found with documents, right? A heat.
Objection, Your Honor.
What?
What is the objection?
Relevance, I'm not sure what the relevant, even if we're impeaching him via inconsistent statements, I guess, for a report that's written, I don't see the relevance in terms of the probable cause determination at this time. I mean, with all due respect to Officer Lujan, we're not grading him on his writing ability at this juncture.
Okay, I am going to overrule the objection at this point. I do find the cross-examination to be relevant. Please proceed, Mr. Rashid.
Thank you. Go ahead and answer the question.
Yes, sir. Once again, I'll answer it. I'm human. I make mistakes. I work a lot of hours. I can't be perfect all the time. I would love to, but I can't. So there's some grammar errors. I wasn't always a strong student in English and stuff like that.
Well, I'm not talking about grammar. I'm talking about if you say that she has a head injury when she doesn't have a head injury, if you say that she removed her footwear when she didn't remove her footwear, and if you call her a he instead of a she, those are mistakes that you're not supposed to make, correct?
Like I said, I testified to how it was. You're reading my report that I never testified to, other than, he or she. I never called her a he. I never said she had head injuries. I never said that she removed her shoes. It's just one of those things in my report that you're referring to, that you've had multiple months to review. You're finding those little errors that I made as a normal human being.
All right. So when we get to the walk and turn, you indicated that there's the instructional phase and then there's the walking phase, right?
Correct.
And in the instructional phase, there are 2 things that you're trained to look for, correct?
Yes, sir.
Cannot keep balance while listening to the instructions is the first one, correct?
Correct.
And that means if you tell her to get in that heel to toe position and stay there, if her feet separate while you're explaining and demonstrating the test, that's something you're trained to look for, correct?
Correct. That would be classified as a clue.
All right. And she didn't exhibit that clue.
Never says she did, sir.
I didn't say you said she did. I'm
Right.
saying.
I'm just clarifying. I'm sorry. I'm just clarifying.
Okay. So, another issue is if a person doesn't finish listening to your instructions or doesn't wait for the go signal, you're trained to look for that. And that's a clue if they start too soon, correct?
Correct. Yes, sir.
And my client didn't exhibit that clue either.
No, sir.
All right. Now, you testified that she used her arms for balance during the first series, right?
Yes, sir. She did lift her arms from her side more than 6 inches during the first series, and a little bit during the second.
How do you know that it was more than 6 inches?
Like I said, based on my training experience, we all kind of, have a good idea what 6 inches is. Her arms went a little bit above the mark where I felt it was a little bit more than 6 inches.
All right. And then the steps offline, you said happened on the 9th step of the 18. I mean, the 9th step of the 2nd series, correct?
Yes, sir.
You are trained to look for whether she stops while walking, and she didn't.
Correct.
She took the correct number of steps,
Yes, sir.
and she even did the turn correctly.
She did. Yes, sir.
Would you agree with me that if there's a clue that a lot of people mess up, it's probably the turn?
Based on my experience, that is a more common clue that is indicated during a DWI investigation, but it's not always there.
All right. And then you're saying that she missed heel to toe on step 1 of the 2nd series
Yes, sir.
for a total of 3 out of the 8 things you're trained to look for.
Yes, sir.
And then you again indicate a noticeable sway during the instructions.
Yes, sir. When I'm giving her the instructions, she's swaying from left to right.
So Officer Lujan, tell me when you told her before the horizontal gaze nystagmus test that you expected her to stand perfectly still with no movement.
It's just like the question where you said, do not lean against my bumper while you roll up your pants. We don't tell them that. We just make observations, sir.
Same thing with the instructional phase. You're having her stand in a heel to toe position. A left to right sway isn't a clue, correct?
No, sir. It's a cue, just an indicator that we're looking forward to see how she's performing so far.
And again, you didn't tell her on that test that she had to remain perfectly still.
No, sir.
During this testing, you were advising or instructing my client on the test while she listened and just doing it verbally first, right?
Yes, I was giving her the instructions, getting her in the requested position. Yes, sir.
And so you would go through the instructions and ask if she understood
Yes, sir.
and if she had any questions.
Correct.
And she didn't.
No, sir. The
Even
only
before
question.
your demonstration, correct? She didn't have questions.
Correct.
Then you demonstrated it and she followed your instructions.
As into what? Follow my instructions.
The walk and turn test where you're expecting her to stand in that position while you explain it, not to move until you tell her to.
Oh, yes. Yes, sir.
Take
General
9
questions.
steps down that line, to turn at the end of the 9 steps and take 9 steps back.
Yes, sir.
Was there any problems with those instructions that my client exhibited?
No, I mean, I didn't document anything other than that. She listened, she followed the instructions. The only question she had was which was going to be her first step, which I clarified, which was her left.
Okay. And the last test that you gave was the 1-leg stand.
Yes, sir.
And on the 1-leg stand, a person is expected to lift their foot and keep it in the air for 30 seconds.
Yes, sir.
On that test, did you tell her anything about whether she could or couldn't sway?
No, sir, I did not.
And your testimony is that she used her arms greater than 6 inches away from her side on that test.
Yes, sir, I would say that.
So even though it isn't a clue, you're requiring a person count on that test, right?
Correct.
And count by thousands, not by 1, 2, 3, but they have to 1001, 1002, or 2, 1003, 1000, however people do that, right?
Yes, sir.
And she counted to the number 21, correct?
Yes, sir. 1021.
And did she make any mistakes in her counting on the one leg stand test?
Not that I can recall. She counted up to 1020. If there was any issues, I would have noted it.
And she didn't have any problems with the counting to 9 on the walk and turn test twice, right?
Correct.
Now, this conversation that you have with her afterwards,
Yes,
okay,
sir.
You acknowledge that it's very close, quote unquote, right?
Correct.
And you ask about whether the passenger can drive.
I asked, yes, so why isn't he driving? Something in that nature.
Why?
Why? Due to the fact that I'm just giving more information as to Ms. Travis's statement. And as I asked him, why isn't he driving? She advised that he's been drinking a lot more than she has. And then that's why she was, driving. So just statements, just to get more information.
Why does it matter to you what her passenger consumed as long as they're saying, yeah, he can't drive?
Like I said, I've been doing this for quite some time. Some statements have been in the past. I'm not, referring to anybody specifically, but the change of the statements provided, oh, he's had 5 beers, I had 4 beers, that's why I'm driving, and stuff like that will change. So that's why I asked those type of questions, sir.
Oh, did you ask the number of beers or anything like that?
No, I said that's how we get more of the inconsistent statements provided by the drivers. Not in
Right.
this instance. That's why I said I didn't talk about anybody specific, just in my past experience.
Why does it matter how far she has to go home?
Like I said, it's just one of those things. Ask a question. We normally get the questions, oh, I'm right up the street, I'm around the corner, I feel like I'm safe to drive. But in this instance, she even said that it's a long drive, and it's just to get more statements provided, by Ms. Chavez.
Well, Officer Lujan, you were asked about your 600 DWI investigations that you've done-ish, right?
Yes, sir.
These questions aren't questions that you normally ask drivers, are they?
Not all the time. There's been some, occasions where I have asked further questions after the SFSTs. There's also been, investigations where I conducted the HGN test again. It's just one of those things. I don't have to, pull out my handcuffs immediately after they're done and make the decision there. This is where I get more into the information and to, see how solid my case is, to make sure I'm actually doing my job rather than just making a bad decision.
So asking where a person lives is part of a DWI investigation, typically?
Yeah, it's a question. It's unusual questions that we're trained, they don't tell us specific questions we have to ask. It's just unusual questions. How far do you live away from here? To see if they're changing, direction of where they're headed, where they're, coming from, stuff like that. It's just unusual questions that we're trained to ask.
Asking where a person lives isn't unusual, is it?
It could be. I feel like it is. Not a lot of people are used to answering those questions. More people are like, well, my driver's license. And most of the time, those addresses are not accurate. So we ask more, questions just to determine more facts in the case.
So when she says, I feel like I can make it home, and offers to take an Uber if you would like, your issue.
Honor.
What is the objection, Mr. Coleman?
I would just ask that Mr. Rashid use the exact verbiage, because he's changing the connotation of what she said. She said she could believe. That is what has been administered into evidence via the lapel video. And so I would just ask that Mr. Rashid use that verbiage. when asking this question, because it changes the connotation of what she was saying.
Okay, Mr. Rashid?
Judge, I don't, I'm doing the best I can to take notes and go through. If I stated it in a way that mischaracterizes it, I apologize. It's not my intention. But the officer testified that it was concerning that she was agreeing to take an Uber by pulling her vehicle off the freeway first, instead of just agreeing to be picked up right there on the freeway. That's a statement that I'm entitled to ask him questions about. That's a circumstance I'm entitled to ask him questions about.
I'll overrule the objection. He can ask and clarify the question. Mr. Cullen, I don't find it's a mischaracterization, but I understand what you're saying. But he can continue on with the question to clarify.
Thank you, Your Honor. So, Officer Lujan, it was concerning to you that she would agree to pull her vehicle off and then take an Uber as opposed to an Uber picking her up on the freeway?
It's one of those things. I mean, I could tell her, yeah, I can let you drive away. You're going to pull off on the next exit and ultimately get a ride home. I don't know. I could be lied to all the time. Ms. Chavez could got back in her truck and drove away once I drove away. It's kind of one of those things. It's concerning. Ms. Chavez clearly stated, I believe I could drive home, but if you would like, she even had doubts that she could, fully drive home safely. Those are the statements.
She did not ever express doubts that she would make it home safely, did she?
It's kind of one of those things. I mean, we can sit here and, determine what believe means, but in my interpretation of it is I believe I could do something. There's a chance I can, but there's also a chance I can't. So it's just one of those things.
Is my client's opinion of her ability to drive even relevant to your investigation?
My relevance, yeah, because your, client, she knows herself the most. I don't know her. That was the first time I ever met her. So, she was very respectful. She, the entire time she answered my questions. So I felt, this individual probably wouldn't be lying to me as much as some of the other cases I've experienced. So yes, her clarification of her believing that she can make it home, it did have a little bit of weight to it.
You trusted her opinion regarding whether her passenger could drive, correct?
Like I said, she didn't give me any indicators that she was lying to me. So yes, I mean, she, has been honest the entire time.
Okay.
I felt.
If I can have just a second, Your Honor, to go through.
Of course.
I'm going to mute just to confer with my client briefly, Your Honor. If you don't mind. Thank you.
Of course.
Your Honor, I don't believe that I have further questions for the officer at this time.
Okay. With that, Mr. Conlon, is there any redirect examination for this motion?
Yes, Your Honor.
Okay.
Officer Lujan, I'll just get one of the things that unexpectedly came up out of the way. Were you writing your report simultaneously during your investigation with the defendant?
No, sir.
Okay. Does your police report make the decision for you to arrest somebody?
No, sir.
And did you make mistakes in your report?
Oh, yes, sir. Mr. Rashid pointed it out, which mistakes I've made. So, yes, sir.
And is your body camera that you wore that evening an accurate representation of the investigation you conducted that night?
Yes, sir, it is.
Okay. And at the very beginning of Mr. Rashid's cross-examination about 45 minutes ago, do you recall all the different cues he asked you about?
Yes, sir, I did.
Would you say, off of your training from NHTSA, roughly 50-ish cues you can look for during the initial portion of your investigation?
Yes, there's many clues. I can't tell you exact number, but there's quite a lot of cues that I could look for.
Okay. In your 600 investigations or so, have you ever seen a defendant exhibit all 50-ish ballpark cues that Mr. Rashid went through?
No, sir.
Okay. Are you required to see a certain amount of cues to just have probable cause?
No, sir.
Okay. Is traveling 24 miles an hour over the speed limit a traffic violation?
Yes, sir.
And is it your belief there's a difference between someone saying one shot and then someone saying one shot and one beer?
As in differences to what? I'm sorry.
Differences in the amount of alcoholic beverages consumed.
Yes, sir. If they say one shot, it's, it could be different than one shot and one beer because that's now 2 drinks.
Okay. Is 7 o'clock different than 10? Are those 2 different times?
Yes, sir.
Okay. What time did the defendant initially say she last had a drink?
Initially, she stated at 10 p.m. I believe that's when she said she finished up.
Okay. And are you required to see, again, Mr. Rashid went through, I believe, every clue individually, correct, outside the HGM?
A good majority of them, yes, sir.
In your 600 investigations, based off your experience, is it common for you to see all the clues on the walk and turn and the one leg stand?
No, sir. Every DWI investigation is different, but no.
Are you supposed to ignore statements made by the defendant?
No, I mean, statements is kind of important. This is where you're going to hear some of the facts in the case.
Are you prohibited after your standardized field sobriety test from having an additional conversation with the driver?
No, sir.
And after the defendant's statements to you, were her statements the only reason you arrested her?
No, sir, it was not.
Did you only arrest her because she was speeding?
No, sir.
Did you only arrest her because you observed 3 out of 8 clues on the walk and turn?
No, sir.
Okay. Why did you arrest her?
It was based off the whole totality of the circumstances from, the moment I came in visual contact with the vehicle to having personal contact with Ms. Chavez. The statements that she provided to me, the emission, the drinking, the odors, the performance on the standardized field sobriety test, and then the statements even afterwards. It's based off the whole totality of the circumstances, what made me reach my decision.
Thank you. No further questions, Your Honor. And for the purposes of the probable cause challenge, the state has no additional evidence to present at this time.
Okay, thank you. And Mr. Rashid, did defense want to present any evidence with regards to your motion?
No, Your Honor, but I would ask that we take a quick 5-minute break before we go to argument.
Okay, no problem. And so, Officer Lujan, it's your choice. I could move you to the waiting room during the argument portion, or you can log off and wait for the DA to give you a call. What would you like me to do?
If you would like just to put me in the waiting room, it'd be a little easier for me.
Got it.
This instance.
Nope, no problem. I'll go ahead and move you to the waiting room now. We'll take a 5-minute recess. We'll reconvene at 4:06 for argument.
Thank you.
Sure. Okay, parties, let's reconvene in State of New Mexico versus Miranda Chavez, T4DW 2021-613. All of the parties are present. We're now ready for argument. For a suppression hearing, I usually start with the moving party. So Mr. Rashid, I'll start with you.
Thank you, Your Honor. Your Honor, I think that this case is a great example of some of the inconsistencies that apply in DWI investigations where officers get to rely on information, discard information, take what they deem to be important and emphasize that, and then minimize the things that they don't think are important. And what is required of the state here today is that they prove to you that this officer, based on a totality of the circumstances, had probable cause to arrest Ms. Chavez for DWI. In other words, that her ability to operate a car was impaired, either mentally or physically, to the slightest degree by alcohol. You can use the clear judgment and steady hand phraseology if you want, but the bottom line is, has the state established that my client was impaired either mentally or physically to the slightest degree by alcohol here? And under the circumstances, they have to make the connection between the alcohol and what they are complaining about in terms of her behavior. In this situation, we have somebody who, yes, she's speeding, but I don't know that 89 miles an hour on I-25 is ever something that really shocks or surprises anybody. People travel at a high rate of speed on the freeway. She indicated that she was getting on the freeway from Comanche, that it gets congested there, that she merged over, and that's why she was speeding. The critical part about it is that speeding is not a visual cue that officers are trained has a correlation to DWI. I never argued that there was not reasonable suspicion for a traffic stop here. I never argued that speeding is legal. I never argued anything of the sort. But what I did establish is that of all of the visual cues that officers are trained to look for, somebody going a consistent speed, even if they're speeding, is not one of them. So there is no correlation between the speeding and alcohol, and the officer has acknowledged that. With reference to his approach of the vehicle, well, before that, he engages emergency equipment. My client from the fast lane moves over to the far right lane. She signals her movements all the way across. She doesn't cut off any vehicles or do anything with reference to pulling over that isn't safe. She pulls over safely to the right side. The officer makes the passenger approach. My client has the wherewithal at that time to have registration, driver's license, and insurance ready for the officer as he approaches. He's trained to ask for those three things, and sometimes people will provide one and forget two, or they'll provide two and forget one. And that's all stuff he's supposed to pay attention to. But he doesn't give anybody credit if they have all three of them ready for him when he walks up to the car. Then he detects the odor of alcohol. Nobody's disputing that there was an odor of alcohol. An odor of alcohol is indicative of there being some type of alcohol consumption, but it's not indicative of how much or any level of intoxication. We get to him having her exit. She exits the vehicle safely. She walks to where he asks her to. She assumes the positions that he asks her to. He administers the horizontal gaze to her. She never moves her head. He never has to remind her to follow the finger. He never has to tell her not to anticipate his movements or any of the litany of things that we hear that people do on HGNs, and the officers acknowledge that she didn't exhibit any of those. When we get to the walk and turn test, Judge, this test is they act like it's the easiest thing on the planet, and it's not. For somebody to stand in the heel to toe position while Officer Lujan goes through that entire explanation, then tells her he's going to demonstrate it, then asks if she has any questions, and she's maintained that heel to toe position in the instructional position and never breaks her feet apart, which is what is considered the clue. The next clue is, does she start too soon? Which she didn't do in this case. There is, does she take the appropriate number of steps? Which she does. Does she touch heel to toe on every step? He says there's one step that she missed heel to toe on. I didn't see it, but I'm not gonna, I don't know. I don't think it's visible that he could testify that that's a clue. When we talk about using her arms for balance, we see that her arms aren't flat at her side the entire time, but I don't know that they're greater than 6 inches away from her side. And I don't know that that is such a scientifically based thing that he can say, well, everybody kind of knows what 6 inches is. Well, if 6 inches isn't a clue, but 6.5 might be, I think it's incumbent upon them to establish that to the court. We also have, and I'm sorry, I have so many documents that I need to rely on to do this, but he says that she steps offline on step number 9. I don't know if that's offline. I know that her foot is canted a little bit, but I don't think it's offline, and I don't know that that counts as a clue either. We get to the one leg stand, and my client is able to keep her foot up for the entire 30 seconds. She counts properly. She doesn't mess up her counting. She doesn't put her foot down. She doesn't have any significant sway that I can see. And he says that, again, we have the feet away from her. Her arms away from her side. I don't think we're talking about greater than 6 inches. It's at that point that he gets into this conversation with her about, well, how far do you have to go? And, well, what about him? Has he been drinking? And these aren't questions, as the officers talked about, that are challenging, difficult, unusual questions that an officer's trained to utilize to help make a decision if somebody's being arrested. I've done a million cases with Officer Lujan. I know that the court's done a million cases, and I've never heard Officer Lujan or any officer on state police have this extended conversation at the conclusion of the field sobriety tests about, well, do you feel like you're safe to drive? Do you feel like you can drive? Do you feel like he can drive? Do you feel like, well, and then she offers. She's like, I think I can drive fine. I think I can make it home. But if you would like, I'd be willing to pull my car over and get an Uber or whatever else she's going to say, being cooperative, being appropriate with the officer. She's not agreeing with his assessment as the state has characterized it. And it's clearly not an agreement as to the assessment. Otherwise, we wouldn't be here. So under the circumstances, the amount of time that she has to drive, he starts thinking about, it seems that he was, maybe going to let him drive if he hadn't been drinking, but she tells him he had, and he's had too much to drive. So she offers, but that's not an acknowledgement or an admission that she was impaired by alcohol and wasn't able to drive. What we have here is a speeding stop, excellent field sobriety tests, no slurred speech, a reasonable amount of alcohol admitted to. The officer has testified under oath that my client was honest with him. And I think that the court can see that. So under the circumstances, Officer Lujan did not have probable cause to arrest Ms. Chavez for DWI that night. These are the kind of field sobriety test, Judge, that on my best day of my life, I don't think I could have done. And we know that after all of that, we have the NHTSA manual and the NHTSA training and the standardized field sobriety test instructor training, and then the master instructor training, and all of that to get to a conclusion for the court that, yeah, there's no specific number of clues that tells us we have probable cause to arrest or not, which I think is inconsistent and incorrect. But regardless, the state has established 0 base standards for the court. None. They don't say a person who isn't impaired shows this, and a person who is impaired would show this, or this many, or this number, or any combination of this number, or some standard to apply to the arrest decision. We've got 800 pages of a manual that this officer's been through multiple times, and going through that, he doesn't know and says that there is no specific number of clues that they're looking for. So if there's no specific number of specific clues they're looking for, how can they come in here and say somebody who shows these minimal clues on these tests, somebody that's able to keep her foot up the entire time, doesn't have any problem communicating with the officer, doesn't have slurred speech, tells him and answers every question that he asks her, isn't evasive about any question that she's asked, and we have a circumstance where she does exceptionally well on field sobriety testing and is still arrested. The state has to establish in court today, to your satisfaction, that the officer had enough to arrest that day. In court today. Here, we ignore portions of the field sobriety testing because we're not going to deal with eye movement, and that test doesn't come into evidence. Then we have excellent performance on the other 2 tests. So in court today, you haven't gotten a complete picture. They haven't painted a complete picture for you. And I would submit to the court that you shouldn't agree with the government that they've established probable cause in this case. We believe that Officer Lujan did not have probable cause to arrest Ms. Chavez. We would ask that the court suppress the balance of the testimony and the evidence and enter an order along those lines. Thank you.
Thank you, counsel. And Mr. Conlon, any closing argument from the state?
Yes, Your Honor, as pertaining to the probable cause challenge. Mr. Rashid mentioned at the very beginning of his closing for this motion that this case is a demonstration of what an officer can consider, what an officer is allowed to discard, what an officer is allowed to have a weight. And I would like the court to kind of hold on to that nugget for a minute. So for probable cause, the state's using the jury instruction of 14-4501 as its basis of what we're looking for when making an arrest decision. The defendant operated a motor vehicle, and yes, I apologize to repeat, Mr. Rashid. At the time, the defendant was under the influence of intoxicating liquors, that as a result of drinking liquor, the defendant was less than able to the slightest degree, either mentally or physically or both, to exercise clear judgment. Instead, he had necessary to operate a motor vehicle to the person in public, for the safety of the person in public. Officer Lujan, in his arresting decision, has to consider that jury instruction for probable cause, has to consider the defense ability, either mentally or physically or both, to exercise clear judgment. And so part of this nexus that Mr. Rashid is saying that the state's lacking is this clear judgment. The state submits that the state did provide a complete picture through testimony and lapel video and through the defendant's own statements. Probable cause, the standard as demonstrated by State v. Sanchez, is an officer has PC when the facts and circumstances, when the officer's knowledge are sufficient to warrant an officer of reasonable caution to believe that an offense is being committed or has been committed. And obviously, I recognize the court has heard this many times, but State v. Salas regarding the reasonableness for this objective standard comes that mindful that probable cause requires more than suspicion, but less than certainty. State v. Salas. In that State v. Eden, a 1989 New Mexico Court of Appeals case for paragraph 24, states that a defendant's admission to drinking prior to driving in combination with other factors can also give an officer probable cause to make an arrest for a DWI. The state does not disagree with defense's contention that there were not 50 or so cues observed by Officer Lujan, but the state's asking the court to examine these other factors that were present during this investigation. Number one, speeding. The state recognizes speeding's not swerving, speeding's not crashing, but the defendant was speeding in the left lane, 24 miles an hour over speed limit going 89 and 65. Second, the defendant's own statements to explaining her reason for speeding. She stated she was speeding because she was merging onto a lane. As Officer Lujan testified to the merging lane, lane number 3, lane number 4, lane number 5, the defendant was speeding in lane number 1, clearly not in the merging lane. Officer Lujan detected the odor of alcohol for number 3. Number 4, Officer Lujan detected or observed bloodshot watery eyes. Number 5, Officer Lujan asking about the consumption of alcohol. The defendant states she had no drinks, then she had 1 shot. Then she had 1 shot at 7 p.m. Then she had 1 shot and 1 beer. Then her last drink was 1 shot and 1 beer at 10 p.m. Officer Lujan observed front to back sway during the horizontal gaze nystagmus test. Front to back sway while standing up straight with your feet touching. Listening to instructions, not moving your head, not moving other body parts, standing still, front to back sway, while using her eyes to follow his finger. During the lapel video, number 7, lapel video captures the defendant lifting her arms for balance for a series of at least 9 steps, greater than 6 inches. Officer Lujan, in his instructions regarding during the 1-leg stand, explained 6 inches to be greater than a Coke can. The state is submitting to the court that the lapel video captures the arms away from her side of her body, greater than a Coke can. Number 8, Your Honor, lapel video capturing the defendant stepping off line on the 9th step, Your Honor. The lapel video shows the defendant's heel to toe not touching on the first step of the 2nd series. Number 10, lapel video capturing again the defendant using her arms for balance, greater than 6 inches. Officer Lujan also testified that the defendant had circular sway during the 1-leg stand. And in response to Officer Lujan expanding the questions after the standardized field sobriety test, Officer Lujan testified that the decision to arrest doesn't come from his report, but it's made when he puts his hands on his cuffs after he has all the facts and information present to him. The investigation can move forward after the standardized field sobriety test. It does not need to end after 3. Sometimes officers use the alternative tests that were not used in this case, but he asked questions. Regarding where do you live? In the beginning of the conversation, lapel video captures the defendant indicating that she lives what is on her license, but then she changes that to what's down in Peralta on Los Lunas. Officer Lujan is simply gathering more information about where does she live? Are there any additional inconsistent statements? In number 12, Your Honor, Officer Lujan asked, how do you feel right now? Do you think you should be driving? And Mr. Rashid, in his closing, is discussing the defendant's honesty. And Officer Lujan talked about her respectfulness, but also in the lapel video captures their conversation that he appreciates her honesty. And in her honesty, she says, I believe I could make it home. Not definitive statement, not I can make it home. Not sure I can make it home. Of course I'm gonna make it home, but I could believe. I believe I could. He's allowed to take statements the defendant uses in his consideration for totality of circumstances. No one factor is definitive. In response to questions about why the passenger did not drive, the defendant stated, he was drinking prior, and that is why I am drinking. Not that is why I'm driving him home, but that is why I'm drinking. These statements made by the defendant go to the jury instruction of impaired to the slightest degree, which is what Officer Lujan is looking for when he's making an arrest. He's not saying, I'm gonna have her at this BAC or that BAC. He is simply looking for, is she able to exercise clear judgment, mentally and physically, to operate a motor vehicle? And then, Your Honor, number 14, when officer, it gives the defendant a chance to clarify. It says like, he's trying to at the end of the pub video, have her state, well, no, I meant driving, not drinking. The defendant doesn't respond appropriately to that question. Officer Lujan is supposed to and required to consider all facts and circumstances within his knowledge. That includes statements made by the defendant. That includes everything that he observed, including the speeding, because speeding can go to exercising clear judgment. And so, Your Honor, the state believes it presented a clear picture that there was probable cause for Officer Lujan to arrest the defendant that night for DWI, and the state respectfully requests that you deny the defense motion to suppress and dismiss. Thank you.
Okay, thank you, counsel. And Mr. Rashid, is there any reply from defense?
Your Honor, I believe that I've outlined my argument to the court. I think that this idea that the state is attempting to create something that has been studied, has been looked at, has been reviewed, has been codified through the NHTSA manual, all of the different things that an officer is trained to look for that have a correlation to DWI. That's why they're there. That's why they list them. They talk about vigilance problems, speed and braking problems, problems with lane positioning, all of those things that an officer is trained to look for that have a correlation to DWI, and speeding, admittedly by the officer, is not one of those factors. The speeding doesn't help the state prove DWI. Officer Lujan never said that the speeding helped improve DWI. He never testified that he's been trained that speeding leads to DWI. There's been no testimony that links the speeding to any issue with impaired judgment, impaired ability, impaired decision-making, anything like that. People speed. It's why that isn't a visual cue. I didn't say it doesn't provide him lawful basis to pull her over, but it doesn't help improve the DWI. Her statements don't help improve his DWI, and her field sobriety tests, I would submit to the court, don't help him prove his DWI. Under the circumstances, my client did very well. She was thoroughly communicative with the officer. She responded to every question that he asked her. The issue of the statement at the end, Mr. Conlon is acting like this is a conversation that's occurring between two friends at a bar, not that we have a female in a tank top out on the side of the highway with a state police officer and another one behind him doing an investigation. That creates nervousness. That doesn't indicate alcohol consumption or alcohol impairment under the circumstances. Ms. Chavez did exceptionally well on her field sobriety tests. She was absolutely straightforward with the officer. She responded to everything he requested. She never exhibited significant balance problems whatsoever. She didn't exhibit any problems with the instructions on the test or not following those instructions. And I'll point again to the stupid turn on the walk and turn. We hear case after case after case. They turned the wrong way. They didn't use the short, choppy steps. They just did a pivot. They just did an about face. And they don't sit there and leave that front foot planted and take the short, choppy steps around as they turn. She followed all of the instructions. Under the circumstances, I'd submit that we aren't supposed to take Officer Lujan at his word for everything here. We are supposed to challenge the evidence, and we're supposed to require that the state prove it. And the state has the obligation to prove that issue to the court. And I don't believe they've proven it to the court. Even if you take the evidence in light most favorable to the state, which we're not at that stage yet, but we don't have enough here for Officer Lujan to have effectuated this arrest. We're asking that the court suppress the balance of the evidence and testimony and enter that appropriate order. Thank you.
Thank you, counsel. Okay, so parties, in the event of a motion to suppress for lack of probable cause, the court must determine whether or not the facts and circumstances within the officer's knowledge are sufficient to warrant an officer of reasonable caution to believe that an offense has been committed or is being committed. The court heard testimony from New Mexico State Police Officer Raimundo Lujan, who testified that he pulled the defendant over. She had been driving 89 in a 65 on I-25. While I recognize a good number of people speed on I-25, she was caught doing 24 miles over the speed limit, which gave him reasonable suspicion to at least stop the vehicle with regards to the speeding. It is of note that no other bad driving was observed. There were no issues with the stop. The officer came into contact with the vehicle first on the passenger side. The defendant was able to collect her documents and provide those to the officer. The officer smelled the odor of alcohol within the vehicle, which led him to then pull the defendant out of the vehicle to further investigate. The officer testified that from an arm's length, he could smell the odor of alcohol emitting from the defendant. He also testified to observing bloodshot, watery eyes. During the conversation with the defendant, she admitted to having two drinks, one shot and one beer prior to driving. Said that she did have those at her work at Left Hand Distillery. There were no documented problems regarding her exit of the vehicle. Based on the officer's observations and the defendant's admissions, the officer then gave 3 standardized field sobriety tests. With regards to the horizontal gaze nystagmus test, the only testimony regarding any potential intoxication had to do with a sway. Based on the angle of the video, the court could not observe the sway during the horizontal gaze nystagmus test. That then led to the walk and turn test. The officer gave the instructions appropriately. The defendant indicated she understood. Within the walk and turn test, the officer observed that the defendant's arms were raised throughout on the first 9 and then for part of the second 9. That was corroborated by the court's observations in the video. The officer also testified that the defendant stepped off the line 1 time and missed the heel to toe 1 time. That was also corroborated by the court's observations. I will note those were the 3 clues observed. And Mr. Rashid is right. That was the only time I've ever seen that turn done correctly. But the officer did observe those 3 clues. The officer then moved to the 1-leg stand. As to those clues, the officer indicated he observed a sway and that her arms were raised more than 6 inches. However, the defendant did count everything correctly. The court did observe the sway and the arms being raised. That was all corroborated by the video, but I did note that she did count correctly. After that, the officer engaged in further conversation. I didn't note any inconsistencies there. But again, the defendant did acknowledge that she had been drinking prior to driving the vehicle. Given that the standard is probable cause, I place emphasis on a few things. The driving was in an excessive amount, and the contact with the defendant indicated the odor of alcohol and the admission to drinking the 1 shot and 1 beer at her workplace prior to driving. The fields were a mixed bag. These were better field sobriety tests than other things I've seen, but there were clues observed by the officer. And then the statements made by the defendant at the end did corroborate those observations. With that, I do find that the facts and circumstances within Officer Lujan's knowledge were sufficient to warrant him to arrest the defendant at that point in time. I do believe probable cause was established. Accordingly, I will deny the defendant's motion to suppress any evidence or statements gathered after that point in time. And so with that, parties, I know the Supreme Court order says that we can't take pleas the day of trial. However, this was a very substantive motion with very good questions raised. I think this is a valid motion to raise on defense's part. If the parties would like to engage in plea negotiations at this point in time, I'll make an exception and make those findings for the Supreme Court in order to do so. That's up to y'all. I don't know if you guys have talked about this before, but if you'd like that opportunity, I'll gladly take a recess to give you that chance.
I would like that opportunity if you don't mind, Your Honor.
Not at all. Why don't I step away? And if you guys would just shout out to Nick when you guys are ready for me to rejoin, I'll rejoin when you let him know, okay?
Okay, Graham, can we do this? Just mute your microphone and camera. I will call you personally and we can talk about it that way. Okay.
No problem.
All right. Thank you. Hey, Nick, you can get the judge back if you want.
He's on his way. Thank you.
Okay, parties, welcome back. We're back on the record in State of New Mexico versus Miranda Chavez, T4DW 2020-1613. All the parties are present. And parties, where are we on the case?
Your Honor, I called Mr. Conlon. We had a discussion. I don't need to get the court necessarily involved in plea discussions, but
Okay.
indicated that his hands were tied and what he was offering was not of any benefit to my client to take, frankly. So as much as we would have liked to have resolved this right now, it doesn't look like we're going to be able to.
Okay. With that, then let's proceed to the trial portion of the case. And parties, is there any objection to incorporating the evidence from the probable cause motion into the trial setting?
No,
Your Honor.
not from defense, Judge.
Okay. Okay, with that, parties, I'll incorporate the evidence from the probable cause motion. And so now we're at the trial stage. Let me ask, Mr. Conlon, is there any opening statement that the state would like to make?
No, Your Honor.
Okay, and Mr. Rashid, is there any opening that defense would like to make?
I don't know that it's an opening, Your Honor, but Mr. Conlon is about to bust out all of his stuff regarding the breath testing in this case,
Okay.
and want to argue vociferously regarding the foundation and to get the breath test in. I've done my investigation, I've done my interviews, I've done my document reviews, and I don't believe that there are going to be any issues related to the breath test in this case. So rather than have Mr. Conlon go through his hour rock star list of questions regarding the breath test, we would stipulate at this time that we do not have enough to oppose the breath test submission.
Okay, so I think that's State's Exhibit 3. So there's a stipulation that State's Exhibit 3 would be admitted. Is that your understanding as well, Mr. Conlon?
That is correct. And in that case, Your Honor, the state will not be attempting to admit State's Exhibit 2.
Okay.
And so Officer Lujan is still in the breakout room. And I guess we can just shorten things up a little bit.
Okay, I'm going to go ahead and admit Officer Lujan then into the main room. Okay, great. Okay, and welcome back, Officer Lujan. We are reconvening and continuing on with your testimony in the trial setting. Just for clarity of the record, I'm going to go ahead and swear you in again. Could you please raise your right hand?
Yes, sir.
Do you swear and affirm that the testimony you give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Okay, thank you. So let's start with direct examination, Mr. Conlon.
Your Honor, may I ask why there's any need for direct examination of Officer Lujan if we have stipulated to the admission of the breath test and we've incorporated all of the evidence from the probable cause hearing?
Sure. Up to the state, Mr. Conlon.
Judge, I think for just the record, the state would like to ask, about 10 questions if the court and defense has enough time for that.
Okay.
So the state's not accepting the stipulation to the breath card, so we will withdraw the stipulation then, Your Honor.
Judge, I'm trying to make sure I can show it to you, and I guess I'm not trying to waste Mr. Rashid's time, but
Stipulation, the admission of evidence requires no questioning regarding that evidence.
Okay. And so if the parties are stipulating to the admission of State's Exhibit 3, and then with that understanding, Mr. Conlon, you can just publish that to me. It's been accepted into evidence. With that, is there any other question you would need to ask Officer Lujan?
No, Your Honor.
Okay. Okay. And so State's Exhibit 3 has been admitted into evidence. And so with that, Officer Lujan, you are excused. You're free to go, and I'm sure Mr. Conlon will give you a call later today.
Perfect. Thank you, Your Honor. Thank you, Mr. Rashid, Mr. Conlon. I appreciate you guys. Have a good night.
Thank you, Ray.
Take care.
See you.
Okay, and with that testimony concluded, State's Exhibit 1 and 3 admitted into evidence. Mr. Conlon, does the state have any other testimony to present, or does the state rest?
State rests, Your Honor. Thank you.
Okay. And Mr. Rashid, is there any motion now that the state is rested?
Well, Your Honor, under the circumstances, I don't know that given that the court has found probable cause, And there has been admission of the breath test that a motion for a directed verdict of acquittal would be appropriate at this point. I'm going to leave that there.
And so then with that, Mr. Rashid, does defense have any testimony or evidence to present, or does defense also rest?
Defense rests as well, Your Honor.
Okay. With that resting, we'll now move to closing argument. Mr. Conlon, is there any closing argument from the state?
Your Honor, just that the state asked the court find the state believes it's presented its case beyond a reasonable doubt that the defendant per State's Exhibit 3, which it provided, I believe, to court back in the beginning of May. The defendant did submit 2 breath tests on October. It was now then the morning of October 25th, but stemming from an arrest on October 24th, in which he submitted 2 alcohol breath samples of 0.11 and 0.11. That's over the legal limit, Your Honor, and the state asked that you find her guilty of driving while intoxicated. And then also, Your Honor, Officer Lujan laid enough foundation to justify the court finding the defendant guilty of speeding of, I believe in this case, it was 24 miles an hour over the speed limit. Thank you.
Thank you. And Mr. Rashid, any closing argument from defense?
Your Honor, actually, no. At this time, under the circumstances, you found probable cause, a breath test is admitted. I know that that essentially requires the court find guilt, and therefore, I would just ask that we be able to proceed with sentencing.
Okay, parties, based on the testimony and evidence presented to the court today at the probable cause hearing, I'll incorporate my previous order into this finding, taking it a step further now that State's Exhibit 3 has been admitted into evidence demonstrating a breath score of 0.11, 0.11. All of that being said, I do find the defendant guilty of 1 count of driving while under the influence of intoxicating liquor, 0.08 or above. This is a per se violation with that breath score. As to count 2 speeding, the testimony from Officer Lujan will also be incorporated into this finding, or my order will be incorporated. I do find the defendant guilty of speeding 20 to 25 miles over the speed limit. With that, are the parties ready to go to sentencing today?
Yes, Your Honor.
Yes, Your Honor.
Great, okay. Okay, and so Mr. Conlon, what would the state like me to know prior to sentencing?
Your Honor, the state believes that plea negotiations are always a relevant portion of the sentencing, as the state does not hold against the defendant that she exercised her right to a trial. However, knowing what the plea negotiations are allows the court to make a judgment about what is permissible within the guidelines, whether to be lenient or not lenient, Your Honor. In this case, Your Honor, the state offered to dismiss the speeding and to impose a 6-month supervised sentence that would be non-reporting status upon the completion of FOP. With that in mind, Your Honor, the state's asking for 12 months supervised without the possibility of non-reporting status, no waiver of mandatory fines and fees, imposition of victim impact panel, DWI school. Both sentences would be deferred, and that the the defendant pay any fines associated with the speeding. Thank you.
Thank you. Okay, Mr. Rashid, what would you like me to know?
A few things, Your Honor. Number one, that my client has, other than a couple of minor traffic tickets, doesn't have a record to speak of. She's never been arrested before. This is a first offense. It is not obviously the worst case this court has seen, or that Mr. Conlon has seen or will see, or that I've seen. And I think that my client was absolutely within her rights to file the probable cause motion. And obviously we've been here for 4 hours kind of fighting about it. That being said, when the court afforded us the opportunity to briefly discuss a potential plea, the state is taking the position now that, well, she might have deserved this yesterday, but she doesn't deserve it today because she exercised her right to have her lawyer argue her case. So yesterday she was okay with 6 months of probation and non-reporting status and dismissed the speeding. But today, for some reason, 12 months of supervised probation are being requested with no ability to get on non-reporting status after completing the screening, the DWI school, and the victim impact panel. The state is being inconsistent, and they are punishing my client for exercising her rights. I understand that Mr. Conlon isn't the last word in the DA's office, but he's the only word we get. I'm asking the court to actually sentence Ms. Chavez, not sentence her actions in this case like they have somehow been inappropriate. You have jurisdiction to require a minimum of 90 days and up to 12 months of probation on a DWI charge. The state was offering 6 months of probation before today, and we believe that you should order Ms. Chavez to be on probation for 6 months, that you defer sentencing on the DWI, that she be required to do the screening, the DWI school, the victim impact panel, the 24 hours of community service, that the court order a maximum of 6 months of probation with the ability for her to go to non-reporting status once she has completed those active components. My client has appeared for everything she's been required to. She's had never gone to bench warrant status. She has been entirely appropriate with the court. She's been appropriate with counsel. And I think that she deserves some acknowledgement that this isn't the worst DWI case ever, that she had a right to go to trial and challenge the evidence in the case, and that the court is supposed to be sentencing her, not the legal decisions that are made in this process. If she deserved 6 months yesterday, she deserves it today. If she was a good enough person to get 6 months of probation yesterday, she deserves it today too. And it's not just because my client exercised her right based on the advice of counsel that she should be punished for going to trial today, which is what the state is asking. So we're going to ask the court to defer sentencing on the speeding also, that she be imposed court costs, but she can't be imposed a fine if the state, which they did, also asked for a deferred sentence. So you can't fine and defer. You can defer and impose court costs. That's the way it goes. So we're asking that the court only impose the minimum mandatory court costs and fees that are required, which should be $375 on the DWI and $60 to $80 or so on the speeding. We're asking that the court defer both of those charges and that you impose the 6 months of probation with the ability to go to non-reporting status once she has completed those active components.
Okay. And Ms. Chavez, it's your day in court. Is there anything that you'd like to say prior to sentencing today?
No, sir.
That's fair enough. All right. Okay. Okay, here's what I'll do, parties. First off, as to the speeding charge, I will go ahead and defer the sentence on the condition of completion of a driver improvement school. That's pretty standard in a speeding case, and I think that's important in this case, Ms. Chavez. And second, as to the DUI, what I'll do is I'll defer the sentence. It'll be deferred for 1 year, but you'll also have the ability to convert to non-reporting status upon completion of the first offenders program. So sentence will be deferred for 1 year on the condition that you attend and complete the DWI school, you complete the drug and alcohol abuse screening program, you attend the victim impact panel, you not possess or consume any alcohol or illegal drugs. You shall obtain the ignition interlock license and have the ignition interlock device installed and operating on any vehicle that you drive. You shall complete 24 hours of community service. You shall not violate any laws while the case is pending. You'll need to follow all orders and conditions set by your probation officer. Tomorrow morning, my clerk is going to give you a call to give you the number to probation. They'll set up your intake appointment and assign you a probation officer. Just make sure you have good contact information for that person so you don't fall out of compliance. There are certain...
Now, Your Honor, before she leaves.
What was that?
We will provide her the information
great.
for probation before she leaves.
Good news. Okay. And so that there are certain mandatory costs. Because you're paying the mandatory costs, I'll waive the additional costs of probation. And like I said, probation can convert to non-reporting status upon completion of your first offenders program requirements. I do that for two reasons. One is I want you to move quickly and diligently through all of those program requirements. And two, I think there's merit to what your attorney says. I think he was, this was a well-taken motion. He was right to file it, and there were some important issues to litigate, and I don't want to penalize you for anything. But also, it's your first offense, and truth is, you seem like a nice lady. I've rarely seen field sobriety tests administered with that level of agreeability, and I don't want to penalize you any further. But I do want you to have that incentive to work towards. So you can convert to that non-reporting status. Your attorney is one of the good ones who does file those motions as soon as someone completes all those things. So I fully expect in a couple of months to receive that motion, and I'll gladly sign off on that. The other thing I want you to know is that it's a deferred sentence. So as long as you've been successful with all of these things at the end of the year, this case can be dismissed. And so please be sure to stay in good contact with your attorney, Mr. Rashid. So that way you can have this case dismissed because you've done well. And I think that's important, especially for someone's first offense. You got caught, it happened. And I'm sorry about the ruling. It's nothing personal, that's my job. But you seem like a nice person, and I want you to do well with that probation. And so with that, parties, I'll take care of the order. And Nick, the clerk, will call you tomorrow just to make sure that you got all the paperwork. And so, Ms. Chavez, what's a good phone number for the court clerk to call you?
505-417-9199.
417-9199. Did I get that right?
Yes, sir.
Great. Okay. And so, parties, I've taken care of the order. Is there anything else to address before we adjourn today?
Not from the state, Judge. Thank you.
Not from the defense, Your Honor.
Okay. Well, I want to commend you both. That was some really interesting and well-fought litigation. You both continue to earn my respect, and I thank you all for your time. Ms. Chavez, I wish you well in the future. Take care.
Thank you, Your Honor.